Your lordship and your lordship was related to
For interim,
for extension of
interim order, yes.
what was full. Unfortunately, it was under the heading contested application. Item number 40. Today's
I think
Kali-
40 I will reach. Wait.
the items of today's business I am saying in Optimum, I have to reach the product at the ground. Item number 51, 72, and 80. I am saying only nothing.
Who is the other side?
Otherwise, all better safe is here.
How I can adjourn without informing the other side?
I can inform, try to inform.
Ask your junior to be remain present when called.
My lord, may I have your lordship's kind leave to mention two matters for inclusion in your lordship. Lordship is dealing with item 32, where some tweet was made, and then in the intervention of the learned additional AG, both parties have filed an affidavit. Your lordship, remember that we have also filed an affidavit that we will not challenge anything, and on that ground, one set of revisional application was quashed also. The same matter.
Publication in.
Yes, we are ready with our affidavit. The same matter is here also. This one, the same thing, say precisely same thing, different PS in respect of a parliamentarian.
You have informed the other side.
Yes, my lord, notice has been given. I've annexed notice, and this is another contested application of 2024. It's a chartered accountant.
I am mentioning item number 70, my lord.
For?
70.
For?
Whatever, my lord, my clerk going to sub the extension of interim, then landed friend at the respondent. He told me that this jurisdiction is with the code number 34 because it is a transfer matter under section 407. Entire jurisdiction. So we are pursuing the wrong jurisdiction. So I have to file matter to go with the code number 34. Code number 34 got the jurisdiction of 407 inside jurisdiction. Respective of the year. So let it be released from your lordship this number. My learned friend other side has informed me.
Who is the other side?
Mr. Pobi Mojumdar.
74.
70. Sabbu Sati. Because this jurisdiction has been, then I find notice that it is jurisdiction with the 34.
407, I have no determination.
That is it.
At the motion stage. Motion stage.
No, this is not motion stage, that the hearing matter. All stage has been given to the my lord. Not motion. Hearing matter has been given to you. 407. Sabbu Sati Bhattacharya.
74.
70. 70.
70.
Saji Bhattacharya.
Release this.
I did, okay.
My lord, may I permitted to mention one matter for inclusion in the list, my lord. Hearing matter.
Read or revision?
My lord. Read.
Read not now. You mention after some time.
My lord,
At
kindly
least 15
include it, my lord.
days you wait. 15 days you wait and thereafter mention.
Kindly included, my lord.
No, there are so many matters already in the list and I am only sitting few days. That is half day. Wait
Just
for
included and
at least
list, my lord.
wait for 15 days, thereafter you mention. Next, call the list. Stop the copy. Last occasion, no service was affected.
Well, this is the affidavit of service. We have served by hand
To whom?
to the learned counsel who was appearing. I told you, private party himself, sorry. We had served the state earlier. State came.
And what about the private parties?
Well, that is the private party. Mr. Kesri was there. Mr. Anand Keshri was appearing.
What is the matter about?
Well, case under section 304A. Well, we are the officers of the bank. Well, and very unfortunate incident took place in a currency chest of the bank. Well, they were secured, as your lordship knows, currency chest is a very secure area. Now, there two security guards at the night when there was a power cut in a enclosed space. They started a generator set, and due to the fumes that were emitted by that generator set in an enclosed space, they succumbed because of carbon monoxide poisoning, most probably. Now, this resulted in a case under section 304A.
This is matter of 2012.
Yes, my lord.
So where is the problem to do this matter? Why
No,
it
we
is-
can have it heard out, but before your lordship, no
May
problem.
I fix this matter?
The only yes,
Please
kindly
look at it. This-
does so.
Interim order was there?
In-
Or it was
Interim order was
expired?
there, my lord. It was there till the end of December 2025. My lord, there was some delay of a month. It was filed on the 30th of January
What is the
2026.
stage of the lower court
Well,
proceeding?
the only charge sheet has been submitted, copies have been supplied. We
After-
also need to place the, I don't know whether your lordship will be comfortable with the 161 statements. They're all in Bengali. If your lordship wants
I can
translations,
read,
we can give it to your lordship.
I can read Bengali.
Oh, very well. Then it's okay.
Hmm. But what is the stage of the proceeding? Whether any order has been passed during?
No, Melody. It
during
won't be. It was there till the end of December. As your
December of 2025.
25.
And you have filed
This
after,
was the order. If your lordship kindly.
file an application after expiry.
Yes. We filed it.
Yes. Without without presence of the other side, it is very difficult.
Dhali is there. The learned public prosecutor is there.
Nobody is there who will represent. Because interim order already expired, it is the difficulty to extend and without hearing other side.
But if they choose not to appear. Your lordship fix up a date. I don't think Mr. Kingsley would have a problem.
We have not served the state.
Yes, we have served.
Where is the
On the
service?
last occasion.
Where is the service?
I'll just find it out for your lordship. This
No,
is
no,
not the
last occasion I passed, no service has been affected.
on the opposite party number 2. The state was served. Can I just find it for your lordship?
No, but affidavit has
Date
not
fixed.
been served, no, not been filed. When you have filed
But-
affidavit of service,
Well, on the last occasion, I gathered it was there. If I may just, if your lordship gives me the records, I'll just find it out for your lordship. Well, this was the নইলে এটা দিয়ে দিন, এটা তো মানে এটার অরিজিনালটা এখানে আছে।
no,
এটা job type
affidavit
ke
of
din?
service is there, please.
Yes, my lord, it would be there. হ্যাঁ এটা ক্র্যানটা দেখো তুমি এর মধ্যে তো নাও না।
I think 31st January you have filed the affidavit.
Well, that was the copy, yes.
No, this was served on 6th February. 6th February 2026. You have served the copy.
এটা আজকে রোজ, দাঁড়াও, এর মধ্যে থাকবে এটা ও মানে it is here.
Do you have?
Well, this is with the records. This was given with the extension of interim order sheet.
This was the service of mentioning. This is the service of mentioning. And this service was,
Then kindly pass.
this was written that this
I
matter
understand.
was filed before the Dr. Justice.
Malad
Ajay
kindly
Kumar-
passes it over for 10 minutes. Let my learned friends go through the same and they will find it for you.
Pass over.
My lord, this is that matter where from the Probation of Offenders Act. For my lord of the opinion that my lord will be affirming the conviction and remanding the case back for consideration under the Probation of Offenders Act. What is it?
Last occasion, you sought for
The time
adjournment.
whether
You have sought for adjournment that whether
I wanted to whether I can
court can
whether I can argue on the merits.
merits, yes.
My lord, I am on. My lord, I am not arguing on the merits. My lord, let it be remanded back to the Court of the Learned Sessions Judge, Appellate Court for consideration on the point of probation.
That was considered by the trial court.
That was considered, but
That
not
was
considered by the Appellate Forum.
That is rejected. Where is Faria Hussain? Okay, I am keeping not today.
My lord.
So you want remand?
My lord.
Remand for
Only for the sentence part. For my lord,
probation.
probation. For qualified report from the probation officer and whether he can be released on probation.
That was rejected. by the
No.
Trial court.
That was not
Considered.
considered.
No any whisper in the order.
No whisper in the Appellate Court's order.
Appeal, I am asking about the trial court.
Trial court, there was it was argued by lord that was not considered, but in
That
the,
was rejected.
that was rejected.
If trial court is rejected, whether this court
Well,
can
the
again-
judgment of the Honorable Court, well, which I relied of Justice Dotto, it is mandatory. There it says it's mandatory.
appellate court can also do
My
that.
lord.
Okay, I will see on the next day. Okay, not today. I am keeping not today. Automatically, it will go to the 3 and 4. No, this one.
No,
this
2.
one, 2. Next.
Well, 3 and 4, my lord. I have an innocuous prayer, my lord.
What?
That my lord kindly extend the interim order, my lord, and kindly have it next Friday, my lord.
Why? It is fixed at top.
My
and
lord, I
you are
know that,
asking
my
for
lord.
again that
My lord, kindly.
I will not.
No, my lord, this is the first time I am seeking.
No, I have kept this matter at top.
My lord, I know
You
that,
have
my
to
lord.
do.
My lord, please, my lord.
No.
My compilation is not ready.
It's very difficult for adjournment. You are sought for upgradation. I have upgraded the matter, leaving aside.
No, I have never sought for upgradation, my lord.
No, last occasion you
No,
sought for
he,
adjournment.
my lord, he has done all this. All these mischievous activities, my lord, by him.
What I said is that
Hey,
you should
Duto,
start
yes.
arguing the matter. Every time, my lord, extension when the matter comes
That's
up.
why this is the matter of
2015.
2017 and 2016.
And
My lord, I
What
tell
is
you,
the difficulty now?
my lord, my compilation is not ready, my lord. I need to rely on the compilation. I will conclude on
I will extend your interim order. You prepared yourself. Thereafter, I will.
No, my lord, I am thoroughly prepared. The compilation is not prepared, my lord. And my lord, he is not objecting, my lord.
He will never
Formally, my lord.
object.
But informally, he never objects me.
He
my lord.
will never object, but court has to see. This
My lord, my lord.
matter
One,
since 2016. 10 years.
more than
Original application is
12
pending.
years.
কোনো এতেই হচ্ছে না তোমার আরো
2016, now 2026.
Yes,
My lord,
2015,
yeah.
ওরে বাবা রে বাবা তুমি তো আমি 1981 আমার জন্ম
Well,
থেকে
had
শুরু
the
করো
amount
was there in the bank account, my lord.
How much you would have earned?
I
My lord,
know.
this is my lord, what happens, my
What's
lord?
the matter about?
My lord, 138 NIA.
NI Act.
Huh. 138 of the Negotiable Instruments Act, my lord. What would
After
be the
conviction,
averment?
after conviction.
No. Quashing on the ground of insufficient averment.
My lord, trial could not proceed.
Right.
My lord, non-trial.
Insufficient advertisement can court quash the
My lord, absolutely.
138.
Absolutely, my lord.
With that amount
Absolutely.
kept in the bank account, my lord, interest by.
But he could have filed a
interest
civil
not
suit for that, my lord. If
made.
he
I
is on
know,
money.
My difficulty is that
It is a very simple issue. Is
Very simple
involved.
issue, my lord.
So
Which
why
is why,
you are taking
my lord,
that?
which is why that day I start, I will conclude. Because very simple, but it will not take much time. Madam, next Friday kindly. And kindly extend the interim order till next Friday only.
Next Friday.
Your lordship is, but next Friday we have court, my lord.
On 17th.
17. And interim order till that date, my lord. Not
17th I
beyond
will
that.
be not here.
Oh. Then when your lordship comes back, we'll do.
17th I will be.
kindly make it part-heard and.
It's parted already. Parted, my lord.
Parted?
It's parted. Right?
No,
No?
no.
Oh, then kindly mark it parted, my lord. If
No,
sure.
I cannot pass.
But then kindly mark it parted. In any
17th.
case, these are assigned will be before your lord.
It is 24th. Release this matter on 24th. Interim order is expired.
And Cran is there. Common order
The
passed.
second just
Huh,
passed.
no interim order. No interim. Deeply obliged, my lord, for the accommodation.
May it please your lordships, my lord. My lord, in this matter, I am appearing for the petitioner, my lord. Your lordships may kindly remember, me, this is the fact, my lord, which was extensively argued by me, my lord. And I, my lord, it was adjourned, my lord, for making clarification on the point, my lord, that, my lord, for more than 3.5 years, my lord, even after the period of arrest, my lord, no, my lord, charge sheet was filed. So, my lord, in that case, my lord, legal, my lord, a point crops up whether in such a situation that proceeding without filing any application for extension of time to, my lord, complete the investigation, my lord, for that purpose, my lord, my lord, took time and I have received all the certified copy of all the orders right from the beginning of the, my lord, from his date of arrest and granting bail and up to date, my lord. And I have not found when I can produce it before lordships, my lord, that not a single application was made for a single time for extension of time for carrying on investigation and filing a report in final form. So, my lord, in that case, my lord, the question, my lord, illegal question crops up, my lord, under section, my lord, that is 167 subsection 5 clause 2 bars, my lord, carrying on investigation when there was no extension of time, my lord. It dies is, my lord, court.
Well, your remedy before the.
No, my lord, it is not, my lord, under section 482, my lord, your lordship has inherent power if you're proceeding. And by this time, another thing happened, my lord, one of the accused persons who was, my lord, according to state, my lord, although it is not correct, my lord, on facts, my lord, that he has been discharged and the learned court was pleased to observe that then stop investigation. You cannot carry on investigation because since 3.5 years past, you have not applied for any.
Make an application
No, my
before
lord,
the
that
trial court
will,
to
my lord, that will, my lord, compulsory, my lord, kindly decide the issue. This is a question of records, my lord. Question of records, my lord. Kindly have a look.
Who? Why not present?
No, my lord, another thing crops up, my lord, in the trial court, in executing court, my lord, the learned advocate who is appearing, my lord, I have gotten information, though, my lord, I have not received the copy, my lord, that the opposite party number 2 here in, my lord, he died, my lord.
You
He-
liberty to pray
No, no, my
before
lord,
the
not, my lord,
court,
not now, my lord, kindly, my lord,
seeking,
my lord, kindly not now, my lord, you kindly, my lord, hear this and consider this document, because, my lord, one thing, my lord, that as I have been reported, my lord, although I have not got the received the, my lord, the proper information that the opposite party number 2 here in, my lord, who on whose behalf, my lord, complaint was made by the learned advocate on the basis of case registered, he, my lord, expired, but that report is to be required. So at this stage, my lord, I cannot proceed. This is the thing, my lord.
the opposite party.
Yes, 2. That is Samuel Kumar Das, my lord. But I have to, my
Expired.
lord. Yes, but that is my unofficial report, unsupported by document. My lord, that was the report, my lord, that referred to in the by the police, my lord, before the court, my lord. I have to collect the documents also.
It is informed to this court that the complainant, de facto complainant, Sri Syamal Kumar Das, opposite party.
My lord, kindly
Then-
don't record this, my lord, because I have unofficially received, my lord, unless I have got the order.
I will ask for report.
Yes, yes.
Is expired. Let a report be.
My lord, kindly keep that.
All the orders.
Yes, yes, my lord. That will be good.
Okay, liberty is given to the petitioner to file supplementary affidavit enclosing all the orders of the
All
trial.
the orders, my lord, please.
Lord, I'm a life convict. From time to time, I was granted parole. On the last such parole, I was granted parole for 4 days for my child's wedding. So I came on parole.
For parole.
I came out on parole. I was to report to Garden PS. I reached the PS. They made me sit.
They made me sit.
After some time, I was informed that I have committed an offense. I have assaulted a complainant, although the sections were bailable, that I have committed the offense. Therefore, my parole is cancelled. This is informed to me by the OC of the police. 1. 2. Now, your lordship kindly comes to the formal FIR.
No, upon cancellation, have you surrendered?
I'm inside the custody. I have taken
What
back
is the prayer?
from the place.
Passing of the
Yes, lordship.
passing of the
Yes.
present case.
Kindly comes to the formal FIR.
What is the stage of the investigation?
By this honorable court.
Yes.
My lord, I'm appearing for the opposite party. I'm praying for Passover as my senior, Mr. Arnab Chatterjee, is engaged before court number 8.
You take note. Let him submit.
In the meantime, my lord,
Yes.
we have served upon the state a supplementary affidavit. Lord, I'm filing it. Yes,
Have you served the copy to the opposite party?
No, we did not know the opposite party is appearing
To
today.
the opposite party, then come.
Lordship will hear me to them, Lord, for 10 minutes.
How? Let the
Lord, the
opposite
answering respondent is the state, Lord.
state.
I will serve. Lordship will fix it.
Washing is being prayed, even the complainant
Yeah,
has a right of it.
Of course. I cannot stand in the way.
Serve the copy and then come.
Kindly fix it on next Friday, my Lord.
Next Friday, I will not be there. On 24th, I am fixing.
Thursday, my Lord.
24th. 17th, I will be not here.
Lord, then 24th, 23rd is You don't have.
24th, I am asking about.
No, there's a voting on the 23rd. That is why I was saying. 24th.
Asking on 24th.
As a lordship, please, bro. Top of the list.
23rd, I will not be here. Affidavit, before I will be there.
Much obliged.
Well, I am for the petitioner.
It is a disposed of matter that was called for by your lordship, by your lordship's earlier order. Lordship, kindly please your lordship's earlier order. That is a disposed of matter. Your appearance is not.
Restoration. Restoration কেন হবে কি dismiss for default নাকি?
No, huh?
আমাদের আগের application করে গেল।
Your question involve once the coordinate bench rejected his prayer, second revisional application will not lie.
Yes, that's the preliminary objection.
That I want to inquire from the file which was called for 1448. Who are the petitioners? Whether they have come in this revisional application or not.
That I have said in my supplementary affidavit. You need not bother.
Rita Saha, Maya Saha, Uttam
I
Saha.
have stated in details.
Same person is here also. Same person.
Yes,
The second revisional application will lie or not, that is the question here.
my lord.
First legal.
My lord, first thing first, my lord.
And lordship,
Similar prayer, quashing.
My lord, I shall deal with that, my lord.
lordship, kindly come to the order, the earlier order, which my learned friend has annexed with the supplementary affidavit at page 6.
Yes, the coordinate bench has
Yes.
narrated
Lordship will get
or
the
observed that this is not fit
My lord.
case for quashing. Yes,
My lord.
let
My
him
lord,
submit.
first thing first, my lord. The earlier revision application, which was heard by your lordship and quashed the proceeding in favor of the petitioner, he was not the party to the revisional application which was moved before Justice Ghosh.
So I have already decided one matter,
Yes,
and that matter, who was the Basanti Saha.
Basanti Saha.
Basanti Saha was not in
The
the
party,
party in CRR
The revisional application,
1448 of
My lord.
2020.
my lord.
So that order I had passed.
Your lordship have passed the order.
Was the
So
proceeding
that order,
so far as the petitioner
Basanti Saha is
Basanti
concerned.
Saha.
Yes.
Now here question
My
is,
lord, my lord. So, my lord, the order passed by your lordship in favor of Basanti Saha, on that order, my lord, there cannot have any, my lord, significance so far the order passed by Justice Ghosh is concerned.
no, there is no any relation.
Yes.
Because that is different matter, two different revisional
My lord.
application, two different petitioner.
And, my lord, in my supplementary affidavit, I specifically stated that before Justice Ghosh, who are the petitioner,
They are the same petitioner
three
here.
petitioners, same. Now, question is this, my lord, whether the subsequent application after disposal of the earlier application by this honorable court would be maintainable or not. That is, my lord, the crux of the case.
Yes.
Now, your lordship sees the order passed by Justice Ghosh. That is in my supplementary affidavit. Sure.
What is the order date?
When is the order dated? Ten May 2022. কি বলছিস তুই আজকে?
Yes.
But in that application, your lordship sees one of the petitioner before your lordship, that is petition number 3. In the present petition, he was not the party.
Uttam Saha.
No, he was Subodhsri Saha.
In that revisional application, three petitioners were there.
She was not the
Saha,
petitioner.
Maya Saha and Uttam Saha.
Maya.
Now present petitioners are here. Maya Saha,
Maya Saha, Rita Saha and Uttam Saha.
Uttam Saha. All the three are there.
No, Subodhsri Saha, who is the petitioner number,
Sri Saha is the additional one.
he was not the party
In that,
in the revisional application disposed of by Justice Ghosh.
no problem.
Now, what is the order passed by Justice Ghosh, my lord? May I place, my lord? That your lordship will find in my supplementary affidavit.
Yes.
Learned advocate appearing for the petitioner draws the attention of this court to the order dated 10 January 2000, wherein the warrant, proclamation and attachment were issued simultaneously. What has seen? So, bone of contention was whether warrant, proclamation and attachment could be issued simultaneously. I have gone through the previous order dated such and such, which reflects that a reminder was issued by the learned court in respect of the warrant arrest. Surprisingly, the order dated 10th January relates that no execution return of warrant of arrest was received by the court. However, the learned court proceeded to issue proclamation and attachment simultaneously. Having regard to the fact there is no subjective satisfaction recorded by the learned magistrate in respect of the proclamation and attachment which was issued on 10th January 2020, I am of the opinion that the same is against the necessary requirement of the provisions of section 82 of the Code of Criminal Procedure. Accordingly, the order dated such and such, so far as it relates to the issuance of the proclamation and attachment is concerned, the same is hereby set aside. So that order
Was set aside. Since there was
and
no
entire consideration was with regard to the propriety of the issuance of the order of warrant of arrest, proclamation and attachment. Then, my lord, having regard to the case diary which has been placed by this learned court, learned advocate of the state, and complicity of the present petitioner, I am of the opinion the present case is not a fit case. Termination of the proceeding. My lord, with greatest respect, my lord, is there any reflection in the order that materials on record to arrive at the complicity of the petitioner is reflected in the order?
No, when the court observed that there is a complicity,
Not termination of the proceedings.
so it
Termination
cannot
of-
be terminated.
Termination of the proceeding. But my submission is this, my lord. This is not the consideration as, my lord, held by this apex court while considering the application for quashing by this Honorable High Court. Well, I can presently show to your lordship, my lord.
Thereafter, you please read
Kindly
the
read.
observation.
If the petitioner surrenders before the jurisdictional court within appropriate, then, my lord, with regard to the, we have got nothing to do with, my lord, the merits of the application regarding the quashing of the proceeding.
No, but your prayer in that revisional application was for seeking quashing of the proceeding. Yes.
Mainly, entire consideration was, my lord, with regard to the propriety of the order of issuance of the warrant of arrest, proclamation and attachment.
But your application was different. If you
But this application, my lord, squarely for the quashing of the proceeding.
you go through your earlier revisional application, there is no any challenge of the impugned order which was
My lord.
issued proclamation.
Yes. And that was adverted to.
But at the time of hearing how such facts came,
So, my lord, the entire consideration was
your prayer was
my lord, for quashing is there.
for quashing of the
Yes,
proceeding.
yes. That's, my lord, the usual prayer. My lord, I shall show to your lordship. ভাই তুমি যদি কমেন্ট করো তাহলে তো মুশকিল, তাহলে তুমি বলো তোমার যা বলার আছে। My lord, kindly I shall place before your lordship one judgment, my lord, 2020, volume 15, SCC 676. And thereafter, my lord, apart from that, after the order being passed by your lordship, quashing the proceeding in respect of the one accused, your lordship considered the materials on record in detail.
Detail in respect of Basanti Saha.
Detail.
Yes.
Now, my lord,
Details will be considered
in
while
detail.
quashing. Yes.
If subsequent to this order, petitioners find that they are similarly circumstanced, they stand on the self-same footing, will you not be entitled to move for quashing of the proceeding on the strength of your lordship's order?
Now the question arises.
Now, my lord, so because of the order passed by your lordship, a different stage, different circumstances has cropped up. Now I find that the case of the Basanti Shah and case of the petitioner is at par. So this is not the changed circumstances, firstly. And, my lord, apart from that, what is the law of the land after pronouncement of the apex court, that if the first in 2024, 2025, that if nothing averred in the first information report attributing the complicity of the petitioners with regard to the commission of offence, so FIR should be quashed. My lord, earlier application, I have said that charge sheet was submitted, but copy of the charge sheet was not there, so 161 statement was not attached with that. In that application,
but the CD was perused by the learned judge.
My lord, that would be sufficient, my lord, with deepest respect, my lord. Deepest respect.
No.
My lord, kindly see one judgment, my lord. 2020, volume 15, Supreme Court cases, 676. My lord, paragraph 5 onwards. 2020, volume 2, HCC Criminal Law. Huh? 2020, volume 15, HCC 676.
Yes.
My lord, see, my lord, what is the observation of the Supreme Court? Volume 2, HCC Criminal. Two 2018, volume 3.
Yes.
Now, my lord, another judgment, my lord, 2020, volume 2, Supreme Court Cases Criminal, page 65. Very short judgment. Kindly have a glance. Very short judgment. My dear Lord.
Yes, paragraph.
Paragraph 2, my lord. Very short judgment, my lord. No. এটা কিটা হবে? এইটা তো 2001, 2018, volume 3 টা পেলে না? 132.
But this is not applicable in this case. How it is applicable?
But kindly says Supreme Court in that judgment also, what held, my lord, this is not the way to dispose or to consider the revisional application.
But you did not challenge that order. You should have challenged that order.
Big lordship. My lord, I am not that your lordship will sit over the judgment of the Justice Ghosh. Why I am citing those judgment? Whether these parameters were followed while the earlier revisional application was disposed of, so far the prayer for quashing is concerned.
Question is,
So, my lord,
while considering the second revisional application,
I not for a moment I am, my lord, making any submission that your lordship consider the merits or demerits of the order passed by the Justice Ghosh. I am only, my lord, if after the order passed by your lordship, scenario has changed And this,
No. How scenario has been?
because
Whatever observation made by me or whatever observation made by the coordinate bench with regard.
there is no observation, my lord. That is not observation, my lord.
Whatever may be a single
My lord, your
line
lordship
complicity
knows, my lord, that,
without going
my lord, your lordship knows best, my lord.
any detailed reasoning, only one line saying your prayer was rejected.
My lord, my lord, bow down.
Hmm.
But my submission is this, my lord.
Now question is here, you are relying upon my judgment.
Not only that, judgment of the apex court. Judgment of the apex court on this point.
Whether any specific judgment.
Judgment of the apex court after the order passed by Justice Ghosh.
Whether
Judgment.
second revision will lie or not. That is the question.
Well, very
here.
latest judgment I shall show to you,
If
lordship.
suppose earlier revision application was decided without giving any reason. For the sake of argument, without any giving reason, that was dismissed.
My lord,
or rejected. Whether second revisional application for same prayer of the same party can lie or not.
my lord, in my humble submission,
That is
yes.
the subject matter here.
My lord, in my
decided
submission,
first.
in my submission, my lord, it is yes. Your lordship knows, my lord, that even the obiter is not binding upon the court. Now the finding that I have considered the case diary and I do not find to terminate the proceeding, whether, my lord, that clinches the issue regarding the merits of the petitioner with regard to the prayer for quashing. I am asking
That
tonight.
is the question here. That is the question
My lord,
here, whether that is
latest
considered
judgment,
as-
my lord, I shall produce with your lordship. 2024, volume 20, Supreme Court cases, page 85. My lord, paragraph 6. Onwards, my lord. But squarely I come within this parameter of this. Now, my lord, paragraph 10. Now, paragraph 13, your lordship sees. May I place, my lord? Paragraph 13, paragraph 14. Paragraph 15, my lord, is crux of the point.
No, here the case is different.
No,
In
no
this-
difference, my lord. There is a judgment, subsequent judgment.
in
Subsequent, pursuant to the subsequent judgment, the fresh petition was moved under section 482.
In this case, earlier revisional application was withdrawn.
Passed,
Withdrawn without liberty
dismissed,
to
withdraw and
obtain,
without taking leave.
without leave.
Without taking leave. So
Apply
that is, my
after-
lord,
whether-
dismissal of the revisional application.
uh,
Revisional application.
withdrawn and dismissal.
Dismiss. So dismissal, my lord. Dismissal
do
is,
not-
my lord, the order,
I do
ultimate
not
order.
proceed. I waive.
My lord,
application.
kindly, my lord. If it is simply withdrawn, I could have understood. Withdrawn and dismissed without granting any leave to move a fresh application.
The withdrawal allowed.
So dismissal order stand. Order of dismissal stand.
If you submit that I withdraw this application with a liberty to file a fresh with a better better.
This is not disposed
point
of.
or
Withdrawal, guardian judge did not pass the order So application is disposed of.
Not
Or,
disposed of,
or
withdraw.
withdrawal, keeping all the points open. Keeping all the points open. So this is a dismissal is the ultimate order. And my lord, how this dismissal came, my lord? The apex court has hinted on it. Kindly look at, my lord. Paragraph 9, your lordship sees.
In this judgment.
Paragraph 9.
Yes, I have seen.
Close on the heels of dismissal of the said petition of the appellant as withdrawn. So, when the application was going to be dismissed, then it was withdrawn. So, my lord, this is a dismissal is the ultimate order. This is not simplicity or withdrawal.
Okay, any other judgment?
My lord, kindly look at paragraph 15, my lord. The legal position as to whether a second petition under 482 would be maintainable or not is no longer res intriga. We may notice a few decisions on this point of this court on this point. Pharmaceutical versus Nita, a decision arising out of the NI Act, the relevant High Court had given the party liberty to avail any remedy in law, if available, at the time of withdrawing her petition under Section 482 CRPC. This court observed that the High Court would have inherent power to decide any successive petition under Section 482, and it is not denuded of that power by the principle of res judicata. Thus, that the principle of res judicata has no application in a criminal proceeding was reiterated by this court in another judgment. Earlier occasion, my learned friend submitted the principle of res judicata. Recently, this court in Vishalal Verma versus State of UP has again held that there is no blanket rule against the filing of successive petition under Section 482 before the High Court. It was also held that if such a petition is filed, whether there was any change in the facts or circumstances necessitating the filing of such petition. Section 482 on its own terms sets the inherent powers of the High Court to make such order as may be necessary, to give effect to any order under Section CRPC, to prevent abuse of the process of any court, or to secure the ends of justice. Change of law can legitimately be regarded as a vital change in circumstances, clothing the High Court with the power, competence, and jurisdiction to entertain the subsequent petition, notwithstanding the fact that the earlier petition was withdrawn without obtaining any leave, subject to the satisfaction recorded by the High Court that the order paid for in the subsequent petition ought to be made inter alia, either to prevent the abuse of the process of any court or to secure the ends of justice. Thus, in our considered opinion, the constricted view taken by the High Court to hold that the appellants were required to obtain leave of the judge who has dismissed the earlier petition prior to filing the subsequent petition is clearly untenable and not warranted in law. It is noted that the appellant such facts of that. Thus, that the decision in Surinder Singh versus Judicial has been rendered by bench co-equal strength have not escaped our notice. However, notwithstanding the legal position that a cleavage of opinion is discernible when to Bamboo Bhander is seeking to explain the law by reading a limited discretion that the appellate court has been conferred. This is with regard to NI Act. Now, paragraph 34. So, two things has emerged from this judgment. two things, my lord, emerge from this judgment. That there is no blanket rule. Principle of res judicata is not applicable so far criminal law is concerned.
Yes.
Secondly, my lord, in order to secure the ends of justice and to prevent the abuse of the process of the court, High Court can invoke power under Section 482. Now, my lord, my humble submission, if the materials on record as considered by your lordship does not permit the continuance of the proceeding, so my lord, further continuance of the proceeding would be abuse of the process of the court. And my lord, the petitioners will be thrown to face a proceeding which is a lame proceeding, which was held by your lordship while considering the earlier revisional application that there are no materials, and finally your lordship held by another judgment that no particulars, the judgment I have brought, my lord, your lordship delivered, that's a reported judgment, that particulars of the commission of offence ought to be averred in the petition of complaint or the FIR, which is totally lacking in this case. So, my lord, whether your lordship will shut your lordship eyes after perusal of the... But this is your lordship's judgment.
Yes, yes, you have annexed.
No, this is another case. It is not in my case. Copy good. Following the apex court judgment,
Yes.
chalo. But paragraph 16, your lordship specifically held.
Yes.
And your lordship followed the judgment of apex court of 2025, paragraph 27.
Yes.
Number of judgments followed by your lordship of the apex court. And ultimately, my lord, paragraph 25, 35.
Yes.
My lord, another judgment, my lord, I shall place before your lordship. The 2018 volume 3 crimes to Zilla. My lord, I have placed before your lordship 2018 volume 3 crime. My lord, 1992 Calcutta Criminal Law Reporter, page 177. Supreme Court judgment 2021 column 3 All India Criminal Law Reporter. देखिए same point was taken in this case, my lord. But paragraph 4, with second division. ওই আগে না না রিজেক্ট হয়েছিল
রিজেক্ট হয়েছিল অন মেরিট ওই কোন প্যারাগ্রাফটা স্যার
Paragraph 4. Yes, that was the submission. What is the observation? Observation.
Dismissed by this court as per the allegation of violation of West Bengal rice and paddy. The second revision, my lord, considered the entire thing de novo. Paragraph 7, your lordship sees. 2021.
Yes.
My lord, another judgment, my lord, very short judgment. 2021, column 3, All India Criminal Law Reporter, page 777. Very short, my lord. My lord, your lordship, kindly consider what are the ratio of this judgment, ratio decidendi of this judgment. If your lordship simply think that in a particular case, it is not that. What is the ratio decidendi on this aspect?
Yes.
Can you look at my lord? Very short judgment, 2-3 paragraphs.
Which one is relevant paragraph?
On the flag, my lord, flag portion. Yes. What was that? 2021, volume 3, All India Criminal Law Reporter, page 777. ওখানে যাই।
But that was the file under Article
Yes.
32 of the.
But quashing prayer was there. Quashing prayer was there for quashing.
Supreme Court has ample power.
My lord, this is the my lord, dictum of the Supreme Court, and considered, my lord, the state of West Bengal versus Mohan Singh, and said, my lord, that there is no bar. I am on that, my lord. If there is no bar in now all these judgment, my lord, 1975 Supreme Court was referred to.
Okay. With regard to the another applicant, that is petitioner number 3, so far as petitioner number
Subrasi.
Subhasri, petitioner number 3 in the present revisional application, what is the merit?
Same thing, my lord. They stand on the same footing.
Same footing,
Yes,
same submissions.
yes. Same allegation.
At least Subhasri, it is maintainable.
My lord, I will submit, my lord, if law does not permit the continuance of the proceeding.
But in respect of any of these petitioners, it is not.
Achha.
I shall satisfy your lordship. Let my lordship conclude.
So on merit, you are standing on the same footing which was decided
By your lordships,
by this court with regard to the Basanti Saha.
Basanti Saha. My only submission is this, my lord, that if materials on record does not permit the continuance of the proceeding, whether, my lord, court will allow to continue that lame proceeding. My lord, criminal proceeding.
Both applications were filed under section 480. Earlier 227, read with 482.
My lord,
And
when
subsequently-
application is filed, my lord, usually we quote the 482. But ultimately, your lordship has to see whether the court has really considered the merits or materials on record to decide the prayer for quashing or not. If it finds, my lord, that entire consideration, my lord, was with regard to the propriety of the order, which was also impugned in the revisional application, and there was a remark that considered, and it is not a fit case to terminate, whether that will be decisive, I am asking to myself. But 2024 Supreme Court has said, no. And when there is no blanket rule for, my lord, banning the petitioner to move for revision after first revision being rejected. Now, if your lordships consider the change of circumstances, my lord, change of law is also a change of circumstance. Change of law is also a change of circumstance. Now, pursuant to the judgment of the apex court and your lordship's court, the law relating to continuance of the proceeding on the strength of these materials has been deprecated by the apex court and your lordship's court. And that judgment came after the order passed by Justice Ghosh. And your lordship order also passed after the order being passed by Justice Ghosh. Now, my lord, one order, if the other accused persons stand, my lord, number of occasions, my lord, we have seen that the bail application was rejected. Subsequently, my lord, a co-accused standing on the same footing was granted bail.
Bail and revision application are two different.
Bail is also an order, my lord. Bail is also an order. Now, my lord, if
there is no bar of any subsequent application in bail application. Several occasions.
no. Supreme Court has held, my lord, bail application, successive application is no bar if there is a change of circumstance. If there is a change of circumstance, the Supreme Court, my lord, in that kind of cases held that this is the change of circumstance. That one accused standing at par with the other accused has been granted bail by a court, and that court you can apply. Then that will not apply, my lord, the successive bail application. Now, my lord, here change of circumstances is in that change of circumstances.
Okay, any other submissions? With regard to the merit, you have said,
My lord, kindly look at the merits of the case. And my lord, and another thing, my lord, in the earlier application, there was no 161 statement. But in this application, I have annexed the 161 statement. Justice Ghosh order said, I have considered the case type. Whether, my lord, that will pinpointed to the
at that point of time also charge sheet has been submitted?
Yes. Whether, my lord, that was pinpointed to the consideration of the 161 statement. Here, only 161 statement at that time was not available to the accused. So it was not annexed to this petition. Now it was annexed. Now my humble...
You did not get an opportunity to place your case at that point of time, since you do not have copy of the 161.
Yes.
That is your...
That was not there. And my lord, from the judgment order passed by Justice Court, it does not reflect that consider the 161 statement.
No, case diary consideration means all materials.
My lord, my submission is, my lord, the case diary considered only with regard to the propriety of the order which was challenged before this court. Case diary was considered, no doubt it was considered only with regard to the propriety of the order which was impugned in the revisional application.
What is it? What does it mean, complicity? Complicity means the entire...
Complicity would be there. Even the order when passed under, my lord, issuing warrant of arrest or proclamation, question of complicity is not the question factor.
That's why I am asking.
Complicity was there. Complicity was there, but the order was set aside because it was procedural flaw.
Yes.
Procedural flaw.
So
complicity with regard to the accused person against whom the warrant of arrest was issued must be there.
At that point of time, the coordinate bench has considered two issues. One, impugned order which was issued, the proclamation and attachment without following the procedure of proclamation
Procedural
and
law.
Attachment.
Yes.
There was a flaw, 82 was not complied, and
on that aspect, my lord, they considered the case diary.
That consideration, the justice quashed the order of
set aside the order. Set aside the order.
Now, next question is whether the proceeding...
Whether that was adverted to. My whole submission is whether that was adverted to.
That was also considered by a single line.
By a single line, by a my lord, single line observation will be, my lord, seal the fate of the accused person when they are entitled.
There is the point to consider whether second revisional application will enable.
My lord, I submitted before your lordship that the case diary was considered with regard to the, when by this court, only with regard to the question of propriety of the warrant of arrest, proclamation and attachment. But so far the quashing is concerned, it was not, my lord, does not reflect that case diary was considered, and it was observed on the case diary, it appears there are ample materials to constitute the offense such and such, such and such.
But you had not challenged the impugned order, you had challenged the entire proceeding, and your prayer was only concentrating to quash entire proceeding, and automatically warrant will be go.
My lord, from the order sheet, does it reflect that the learned advocate asked or made any argument regarding the quashing of the proceedings? My lord, I am asking to myself.
What your pleading is...
My lord, prayer is there. Prayer is there.
You do not argue on your ground or your point.
My lord, if...
It is your own prerogative.
My lord, if the criminal court... My submission would be this, my lord.
Four grounds and you only harping on one point. That is your choice.
My submission would be, my lord.
That is the
My learned friend to give me a copy of the revisional application of 1448
Why?
so that I can go through. Or I shall go through the.
My lord,
only 2 points raised in
my lord,
only
my
2 point raised in that revisional application. The prayer was for quashing of the entire proceeding. And if the entire proceeding will quash, automatically warrant
my lord, my submission would be, my lord.
and specific no impugned order was challenged. From the body of the petition, you will go through. If you find only prayer was quashing of the entire proceeding.
My lord, my submission is this, my
But
lord.
while considering the revisional application, the learned judge or justice has considered to issue whether that impugned order was rightly passed or not, and whether proceeding.
My lord, there I respectfully join issue, my lord. There I respectfully join issue.
Yes.
From the order, it does not reflect that any argument was advanced regarding the quashing of the proceeding. Nothing reflects from the order.
Reflection, yes. That is the admitted position. There is no reflection of any argument regarding quashing.
So, my lord, that point which was not urged before the court, whether could it be said, my lord, that was considered on merits and
that will I'll consider.
Well, kindly consider.
Yes.
And my lord, another thing, my lord.
And relied on so many judgments.
You have noted that judgments. Okay.
What date আছে ওখানে? Mal
Yes. Anybody else? Restoration application section 5 dismissal. Again it will be dismissed. One appears on behalf of the petitioner.
Because he accepts that it was served on us.
Yes, please give me the record. You are appearing.
My lord, I am for the statement.
Earlier you have appeared.
Yes, Mr. Tirthankar Dhali.
Anand Kesri, my lord.
Huh?
Kesri is leading me, my lord.
What is your good name?
Tirthankar Dhali.
And that is
So
the
you have no objection.
Sir, let it be extended and date be fixed, my lord, for hearing, final hearing.
Heard both sides.
yes, my lord, and only I don't know whether my learned friend can bring the case diary in the meantime.
Yes, yes, case diary we produce on the, listen, case diary we produce positively on the agenda.
Lordship, it is a restoration application. The person whom I had served the restoration application, my lord, I could not get in touch with him. And this application is required to
it
be
was
served.
dismissed?
Section 5.
When
It was dismissed on 24th, 28th of April, 2024. My lord, let me, when there is some, there's
Section
a
5 application is the,
Section 5 application, my lord, I have served the restoration application, only the Section 5 could not be served, my lord. Because
serve.
this person, Amanari Pansari,
you serve the copy.
but I had served it.
You serve the copy and then come.
Lordship,
may the copy of the writ petition be also served. We are
Writ-
appearing for the respondent number
Yes, yes, definitely.
3.
I will hear it out the writ application. What is the matter about
Lordship, what had happened? Respondent
Group
number
5?
3. I had served it upon the GP. ঠিক আছে, আমি এটা তো
File the
what had happened, my lord, let me just Lordship will kindly bear with me for a few minutes. What had happened, my lord, this petitioner, my lord, he had filed a writ application way back in 2010, my lord, on challenging the refusal to disburse, my lord, increment in terms of the cooperative rules by the cooperative society. Now thereafter, my lord,
regarding appointment of peon.
Peon? No, my lord. Disbursal of increment. কোনটা দিয়েছিল? এটা
Probir de. This is the case.
Probir de.
Probir de.
Yes, my lord. My lord, this is
The
a
first is classification of writ petitions to appointment of peon under Group 5, Group C. What does it
Group 5, my lord, because this is the refusal on the part of the cooperative society to disburse increment in terms of Rule 108 of the Cooperative Societies Rule. Now, thereafter, my lord, there was a direction for exchanging of affidavits. Affidavits were exchanged, my lord. It was ready for hearing. Now, the name which is appearing, my lord, in the list, the advocate on record, he had,
You sought for an increment.
I had sought for
Increment of the salary with effect from August 2006 on.
Lordship.
That is your prayer.
Yes, my lord. Now, what had happened, my lord, the erstwhile advocate on record, he had stopped coming to court from 2023 onwards. And in the meantime, the petitioner.
You serve and come, then I will hear.
Restoration. Restoration.
No, section 5 is required to
Yes,
be
section
served.
5 I shall be serving because this person, my lord, I'm not.
No effective service has been made.
May it please your lordship, my lord, I beg to appear on behalf of the petitioner in this matter, my lord. This is an application for restoration, my lord. My lord, I find, my lord, this is transferred practically, my lord. My lord, I find that the, my lord, the learned advocate who was appearing, my lord, for the
Within time.
government respondent, my lord.
No, this was within
Yes,
time.
that is within time. But, my lord, only one thing with the private respondent, my lord, I don't find any receipt, my lord, that one private respondent is there, whether he has been served or not. I don't find any, my lord.
No, you have not filed within time.
Yes, my lord.
How it would be within time?
It was, my lord.
Matter was dismissed in the month of on 24/6/2024.
Yes.
And you have affirmed this application in the month of September.
But that is the learned period. I will file an application for condonation of it. And also serve, my lord, the state and also the, my lord, other one private respondent.
Mindful, I am for the petitioner. I was on legs with another court, let's make it dismiss for default. No, my other side is present, is there, my lord.
You have lived in another.
Sir, I was there, my lord, 7 8
practice
days.
in High Court.
My lord,
You must have sent some junior or somebody else, or you may request at least.
I'm tendering apology, my lord. It's my fault.
We cannot.
It's my fault, my lord. It's my fault, my lord. Look, Well, kindly, my lord.
Restoration application, you are not there. Again,
I was present, my lord, 7-8 going on long time, my lord. I went code number 8, my lord. My lord, kindly pardon.
allow.
My lord, my lord.
কে নিয়েছে? Item number 9. তুমি নিয়েছিলে?
নামটা দিয়ে দিচ্ছি। Restorationটা হলো
Item number 12, I am for the petitioner led by Mr. Rajdeep Majumdar in this matter, my lord. Last occasion, your lordship was pleased to dismiss it. We have filed an application for restoration, your lordship. As we could not turn off, my lord, your lordship.
Time.
My lord, restoration we have filed within time, my lord. It is filed very shortly, within 1 week of dismissal, my lord, we have filed. We have also served, and last occasion, we have also submitted the affidavit of services in the record, your lordship.
It was dismissed on 29 January 2026.
My lord.
And you have affirmed the application on
February, my lord.
February. Yes, who is other side?
Your lordship has heard this matter, my lord, out of length at 498, a matter between a railway station master and a teacher. The wife is the teacher, the husband is the railway station master. The entire family has been roped in, your lordship. It is that matter.
Other side is not there. I am keeping
My lord.
not today.
Not today, lordship. Maybe restored also. Maybe restored, my lord, if your lordship. State is here.
Restored.
Maybe restored.
No, দেখুন দেখুন this is an application, CRAN 6 order of heading. This is
Grant 3 is my application for revival of the interim order, lordship. It was,
you are for the petitioner.
I am for the petitioner, lordship.
What is the matter?
Lordship is a 138 proceeding. The petitioner before lordship, they have been arraigned as directors. Now, if your lordship sees the complaint, there's no averment which is required under 141. And as to how I was responsible or whether I was even in charge of the.
So you challenge the proceeding?
I've challenged
judgment?
the proceeding, lordship.
Proceeding.
So the interim order, if your lordship.
Contention is that no averment made
No averment, no.
to the director.
Not even in the complaint, nor in the affidavit.
Where is the complaint?
Lordship, the main petition, if your lordship sees the certified copy.
You are the director.
Lordship. I have been
number 2 and 3.
Before your lordship is, if your lordship has the complaint, Miss Manju Tripathi, accused number 2 in the complaint is the petition.
Manju Tripathi, Chandrasekhar, and Mr. Kamlesh
Kamlesh Devi. They are accused number
There are 3.
2, 3, and 4 in the
2, 3, and 4
in the petition of complaint.
Now come to the averment where you are.
No averment, lordship. Second paragraph, your lordship sees that the accused person on different times placed order to the complainant for supply of TMT bars, and the complainant duly supplied the same to the accused persons according to its order, which in total amounted to rupees so and so. That to discharge his aforesaid liabilities as well as debts, the accused persons issued 2 check bearing number so and so dated 31st of December 2019 and bearing number so and so 15th of January 2020, both amounting to 6,93,600, total amount of 13,87,200 drawn on so and so bank. Now, so paragraph 4, if your lordship sees, is regarding the jurisdiction where the checks were deposited, returned unpaid, for funds insufficient.
So nothing has been stated about your designation or what is your role.
No, the signatory is therefore not come before your lordship. The signatory your lordship knows is responsible because he signed the check. A managing director by his designation is responsible. But so far as a director is concerned, your lordship knows that there has to be some government.
My lord, praying for any date, my lord.
Yes.
My lord, praying for fixing any date, my lord, for the final hearing, my lord. My senior is not present at this moment, my lord.
In this way, I cannot adjourn. This matter is pending since 2020.
My lord, I'm praying for fixing of any date, my lord, for the final hearing, my lord.
Today I am fixing.
My lord, my senior is not available at this moment, my lord.
Senior will never appear.
My
You
lord,
have to assist.
my lord, any
proceed.
date, my lord, any date, my lord, in the next week, my lord.
I have even attached the deposition in the form of an affidavit. That's also the certified copy. The last
Selected that Manju Tripathi was a director and petitioner number 3 was also director
that is there in the cost title of the company.
and 4 was also director.
Director.
But what was the role, whether
Lordship,
they were signatory or not, only they have placed the order.
Lordship, nothing to that effect. Lordship.
That is only a word.
Lordship.
Do you have any supporting judgment?
Let me take up from
Which paragraph?
paragraph 8.
1 minute.
If this is a reported judgment, since we have taken the printout from the Supreme Court website, this is the citation is not mentioned, but this judgment is a reported judgment.
Reported, okay.
Ashok,
Which paragraph you are relying?
paragraph 8, Lordship. 8 onwards, Lordship. Now, if your Lordship may take it from paragraph 9, paragraph 9, page 5 of the judgment. May I please paragraph 9, Lordship?
Yes.
Subsection 1 of section 141 of the NI Act required the complainant to aver that the present appellants at the time of the commission of the offence were in charge of and were responsible to the company for the conduct of the business of the company. In the present case, all that the second respondent has alleged is that the appellants were liable for transactions of the company and that they were fully aware of the issuance of the checks and dishonor of the checks. Lordship, this averment is not there in my case also. Therefore, even if we decide to take a broad and liberal view of the pleadings in the complaint, we are unable to draw a conclusion that compliance with the requirements of subsection 1 of section 141 NI Act was made by the second respondent. The most important averment which is required by subsection 1 of section 141 of the NI Act is that the directors were in charge of and were responsible for the conduct of the company. The appellants are neither the signatories to the check nor are whole-time directors. The decision in the case of SP Mani Mohan Dairy versus Sneha Lata Elango 1 will have no application as in the present case the statutory notice was admittedly not served to the accused. Lordship, even if the notice is served in the absence of an averment, Lordship, the complaint cannot lie. Obviously, the High Court has not adverted to aforesaid two glaring deficiencies in the complaint. Lordship, in those facts, Lordship, since there was no averment, the proceedings were quashed.
Even they have not mentioned about the notice that whom they have served.
Whom they have served, Lordship.
My lord, the change brief for us, my lord.
The
My lord,
paragraph
on the
eight-
last occasion, my
18
lord,
or
we have
18
received the
also.
10 application, my lord.
1 minute.
Lordship, I'd also like to place paragraph 18 onwards before Lordship.
Yes, paragraph
18, Lordship, 18.
Yes.
After having considered the submissions, we are of the view that there is a non-compliance on the part of the second respondent with the requirements of subsection 1 of section 141 of the NI Act. We may note here that we are dealing with the appellants who have been alleged to be directors of the accused number 1 company. We are not dealing with the cases of a managing director or whole-time director. Before your lordship also, there is neither a managing director or whole-time. The appellants have not signed the checks. In the facts of these three cases, the checks have been signed by the managing director and not by any of the appellants. Section 141 is an exception to the normal rule that there cannot be any vicarious liability when it comes to a penal provision. The vicarious liability is attracted when the ingredients of subsection 1 of section 141 are satisfied. The section provides that every person who, at the time the offense was committed, was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offense under section 138 of the NI Act. In the light of subsection 1 of section 141, we have perused the amendments made in the complaints, the subject matter of these three appeals. Lordship, then it deals with the facts of the case. So, Lordship, may come to the next page, page 11 of the judgment. I'll place it from the fourth line from the top, Lordship. The requirement of subsection 1 of section 141 of the NI Act is something different and higher. Every person who is sought to be roped in by virtue of subsection 1 of section 141 of NI Act must be a person who at the time the offense was committed was in charge of and was responsible to the company for the conduct of business of the company. Merely because somebody is managing the affairs of the company per se, he does not become in charge of the conduct of the business of the company or the person responsible for the company for the conduct of the business of the company. For example, in a given case, a manager of a company may be managing the business of the company. Only on the ground that he is managing the business of the company, he cannot be roped in based on subsection 1 of section 141 of the NI Act. The second allegation in the complaint is that the appellants are busy with the day-to-day affairs of the company. This is hardly relevant in the context of subsection 1 of section 141 of the NI Act. The allegation that they are in charge of the company is neither here nor there, and by no stretch of the imagination on the basis of such averment, one cannot conclude that the allegation of the second respondent is that the appellants were also responsible to the company for the conduct of the business. Only by saying that a person was in charge of the company at the time when the offense was committed is not sufficient to attract subsection 1 of section 141 of the NI Act. Lordship, then the section 141 has been quoted. Paragraph 20, Lordship, is the concluding paragraph. It says that person in charge of and was responsible to the company for the conduct, it cannot be read disjunctively but has to be read conjunctively. Paragraph 20, Lordship. Lordship, in my case, Lordship, neither they are signatories before Lordship, nor managing directors, nor whole-time directors. There are no averments, Lordship. Even in the affidavit, I have attached it in the certified copy, there are no averments.
Yes, anything else?
No, Lordship, these are...
My lord, I'm appearing for opposite party number 2, my lord. My lord, since they are praying for a fresh interim order, so even in lower court below, my lord, the date is not in a recent 2 weeks, my lord. So what I was suggesting,
No,
my lord,
I already heard him. Now, what is your submissions regarding that you have not made any averment against the accused persons number 2, 3, and 4? under section 141 of the NI Act. So they are asking for squashing of this proceeding. What
my
to
lord,
say about this?
my lord, as I know, my lord, today matter is appearing under the heading extension of interim order, my lord. And the their CRAN is appearing. And today's matter is not for final hearing. So what I was, my lord, the requesting before this court, it kindly fix for a final hearing. Give me a today time, my lord, either Monday or any day, my lord. So it can be the finally disposed of, my lord.
So in the meantime, I am extending the interim order within time. You have
My
No,
lord,
there's a delay. There's a delay.
delay.
Lordship, they are all residents of Delhi and Uttar Delhi. So what?
When the interim order was expired?
Lordship, the interim order had expired on September of 2024. And
What
this
is the stage of the proceeding? Any warrant of arrest was issued?
no, my lord. There is no urgency for a stay, my lord. That's why, my lord, I'm.
Lordship, my learned friend is not arguing, he's opposing the extension also.
Okay. Heard in part. The non appears on behalf of the petitioner. Matter to নাকি আলাদা আলাদা? All are analogous matter. Who is appearing for the state? देखिए একটু नेक्स्ट देखिए नेक्स्ट मैटर same order 138 matter this all these are 138 same order সব আলাদা আলাদা আছে সেম ম্যাটার আলাদা আলাদা সেম অর্ডার সেম 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 Same. No, none appears on behalf of the petitioner. দেখি রেকর্ডটা দেখি একটু।
One Milord, I appear on behalf of the petitioner. Milord, we are the defendant in a suit for declaration, partition, and permanent injunction. Milord, I had filed an application under Order 7, Rule 11. Kindly, Milord, comes to page 29.
Yes, 29. In
Page
order.
20. No, Milord, this is the earlier round of litigation, Milord, order passed by Justice Banerjee. Milord, the second paragraph, the petitioners are some of the defendants in a partition suit and challenge an order of June 14, 2017, by which their petition under Order 7, Rule 11 of the Code has been rejected. The principal ground urged by the petitioner was that the suit was barred by the provisions of the Benami transaction. According to the petitioners, not only does the bar under the said act operate in respect of the transactions entered into after the act came into effect, but also prohibits subsequent suits being instituted claiming a position that is not apparent from the title deeds pertaining to the immovable property. Since the question has been decided, there is no need to require any immediate fresh adjudication on the matter. However, if the petitioner insists on a issue being framed as to whether the suit is barred by the provisions of the said Act of 1988, the trial court is requested to ensure that a preliminary issue is framed in such regard and the same is answered in course of the decision in the suit without being overly influenced by the order impugned herein. Accordingly, Milord, my revisional application was disposed of. Milord, pursuant to this, kindly Milord comes to page
This order was
31.
passed in the year 2017.
Yes, Milord. Thereafter, Milord, page 31, Milord. I have filed this application
Yes.
for framing of the preliminary issue, Milord. Milord, para 3, Milord. Milord, may I place the application?
This issue should be decided at the time. Trial court is requested to ensure that the preliminary issue is framed as such that same may be answered in course of decision in the suit without being overly influenced by the order. Yes. You have made an application.
I have filed an application. Milord, page 31 is my application for framing of an preliminary issue. Milord, whether the suit is barred by the provisions of Benami Transaction Act or not, Milord, that is the sole issue, Milord.
What happened thereafter?
Thereafter, Milord, the application was decided and the impugned order before your lordship, Milord. I have challenged the impugned order. Milord, the certified copy, last page of your lordship's brief.
Yes.
Milord, order dated 7th of August 2024. Milord, whether the suit is barred by the provisions of the Benami Transaction Act or not. Lord, a present suit has been filed for partition and the
So preliminary issue was framed.
preliminary issue was framed. Now, Lord, if your Lordship kindly goes through the order,
Part by provision
Lord.
of dynamic transaction or not. Acha. Present suit has been filed for partition and permanent injunction. The fact area on which defendant had act upon and claimed the suit barred by the provision of dynamic. As Krishna Chandra Mandal, since this is being the predecessor in interest of the plaintiff, purchased a scheduled property from his own income in the name of his son, 7 sons by registered deed also. And Prabhas Chandra Mandal purchased. There are 2 property involved.
Yes, my lord. Schedule A property from his own income in the name of his 7 sons by a registered deed dated 21st of March 1949. And Prabhas Chandra Mandal purchased Schedule B property in the name of his 5 brothers from his own income by a registered deed dated 15th December 1949. It is alleged that the said fact clearly shows that the suit is based on a Benami transaction, as the plaintiffs have Benami interest in the Schedule A and B property purchased from the income of
all the brothers were plaintiff.
Yes. Plaintiffs have purchased, Miller.
No, in the first deed, seven sons were there.
Yes, Miller.
And the second deed, 5 sons. So 7
brothers, Miller.
12 sons were there.
Yes, Miller.
From 2 brothers, Prabhas and Krishna Chandra Mandal.
Yes.
Okay.
They had purchased, but in the Miller, they had purchased.
Plaintiff have Benami interest, property purchase from the income of so and so. Okay.
Yes, Miller.
For that suit is barred under so and so. Admittedly, the deed in dispute have been executed in the year so and so respectively, whereas the Benami transaction prohibition came into operation subsequently.
Yes.
And as such, there is nothing in the provision of Benami transaction that it has retrospective effect. In section 4 of the Benami, and destroy substantial right to real owners who are parties to the first transaction, merely because the word is declared. So your prayer was rejected.
Yes, Milord. Milord, without giving any chance for adducing any evidence, Milord, this prayer, my prayer for
why evidence is required?
Milord, issue is being framed under Order 14 Rule 2. Milord, kindly Milord grants liberty at least to lead my evidence.
Order 7 rule.
Yes, Order 7 Rule 11. No, Milord. A preliminary issue has been framed. A preliminary issue has been framed under Order 14 Rule 2. Whether the suit is barred under the provisions of the Benami Transaction Act or not. Now, Milord, when an issue has been framed, Milord, for that, Milord, I need to at least, Milord, adduce my evidence. Milord, my evidence were not being allowed to lead, Milord. Milord, the court frames a preliminary issue, whether the suit is barred by the provisions of the Benami Transaction Act or not.
That is your prayer under application under 7 Rule 11 of the CPC.
No, Milord, kindly Milord comes to page
Rejection
31.
of the plaint. So
page 31, Milord, that is my application.
Yes, you have
page
mentioned
31.
paragraph number 2.
Page 31 is my application for framing a preliminary.
Mentioned in paragraph 2.
Yes, preliminary issue has been framed.
So Order 7 Rule 11, where is the provision of giving evidence?
Well, Order 7, it is not deciding under Order 7 Rule 11, Milord. This is a preliminary issue framed under Order 14 Rule 2.
That was framed on as per the order passed by the High Court.
Yes. as per the directions framed by the High Court, my lord, kindly, my lord, since my lord, kindly, my lord, comes to page 29.
That is a law,
My lord, kindly, my lord, comes to page 29.
point of law.
Yes,
whether
point
it is
of
maintainable
law,
or not.
my lord, I absolutely
And
appreciate, my lord.
point of law, how you can adduce evidence?
No, my lord, kindly, my lord, sees there are,
That
my
is
lord,
the admitted facts.
two deeds has been pleaded.
That is
My lord,
admitted fact that
no,
there is
that,
no denial.
that is admitted
Only
fact.
question
Now, my lord,
is
whether
whether it
who
will
were
be
the Benam?
retrospective effect or prospective effect.
No, my
There
lord,
is no any retrospective effect
no,
given
I
in the act.
I absolutely bow down, my lord. Only one thing, my lord, whether they were the Benamdars or not. My lord,
Point of
my
law,
lord,
you can adduce what evidence you will
my lord,
need.
let me adduce, my lord, the evidence, and thereafter, my lord,
What evidence you will need on the point of law?
no, my lord, not only on the point of law, my lord, kindly, my lord, sees there are two scheduled properties. Two deeds have been executed. My
That
lord,
is
there are
admitted fact
there are
that
several
was purchased by their father. Where is
no, my lord, not only by their father but also by one of them by the brother.
father and uncle purchased?
Yes.
They were brothers.
Yes.
So that is admitted, but they have not denied
Lord,
that.
now, my lord, I have to plead, my lord, whether, my lord, who were the Benamdas to the suit property? Who are the Benamdas? My lord, in whose name, my lord, that has been purchased? Lord, that, my lord, kindly, my lord, allows me to only, my lord, to lead
Whose name?
evidence. Yes, the
It
Benam.
itself shows that they purchased in their son's name.
Yes.
So that is admitted facts. Whether they are denying? No.
Lord, kindly, my lord, appreciates here our issue is being framed. Now, my lord, issue has been framed under the
Issue regarding maintainability of the suit.
Yes. Issue regarding
barred by
whether it is barred under the provisions of the Benami Transaction Act or not.
a legal issue.
Yes, my lord.
The legal issue can be decided upon leading evidence. What evidence you will lead? Okay.
No, my lord, only one thing, my lord.
Hard for orders. Hard. Anything else? Next 22. The dismissed. Dismissed for default. None appears on behalf of none appears. Yes.
There is an application, Millard, for Millard extension of interim order can 1. There was an interim order, Millard, which was granted. I was directed to serve, Millard.
No caveat, no?
No, I was directed, revision application has been admitted. There was a Millard stay which has expired. Millard, I have filed an application for extension of interim order, and Millard, there was a direction to serve. I have served.
Can 1 is for extension of
Yes,
order.
yes.
What is the main matter?
My lord, main matter is, my lord, I have challenged. Yes, my lord, sir. I have challenged the order dated 27th January 2025, by which, my lord, my application, my lord, for maintainability of the suit, my lord, has been rejected.
So earlier this was admitted and a stay order was granted.
Yes, yes. It was, my lord, perhaps 2nd of May 2025.
Till the end of month of July 2025.
Yes, my lord.
When you have filed the CAN application?
My lord, it was filed on, my lord, September 2025.
So, beyond.
Yes, my lord, that's why I have prayed for reimposition, not extension. My prayer is for reimposition.
How reimpose? How I can reimpose?
That was granted, my lord. That's why, my lord.
Fresh prayer you have made.
Yes.
But your application is an application for extension and a reimposition.
Yes, yes.
How that can be allowed?
Whichever, my lord. Now I leave it to your lordship.
You have to make proper application.
It was.
Either
It
you
was.
have to make an application for extension, then you have to.
Yes,
make
extension prayer is there. Kindly,
then you
lord,
make an application for.
kindly, my lord, ignores that part, my lord. Kindly, my lord, extends it, my lord, and fix any day, my lord, for hearing. Any day for hearing, my lord, I have served. You know, pursuant to the direction, my lord, I have served.
You have solved the CAN application. You have solved the CO.
Yes, CAN, my lord, is appearing for the first time today before your
You
lordship.
have to solve the CAN application. Because he
Yes,
says
kindly extend it for a limited period. That's fixing your 7th of May.
If they will come, I will hear it, the entire matter.
Yes, 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 yes.
But I have the petitioner, blood. But it is that matter, blood, when the
I
two
have no
elderly.
objection with it, Lordship. The matter was not fixed at 12:30, Lordship. On the last
was.
session, when we were present, I was present, Lordship. The matter was not fixed at 12:30.
But it was, your lordship blood fixed it.
So you are saying it is not fixed.
Lordship, it is written in the list, but when the matter was
So
taken,
you have to follow the list.
Lordship, on the last date, we were present.
Perhaps my learned junior friend, perhaps my learned junior friend is not aware that there is a rules which indicates that the list is a notice.
Yes.
Now, there is
Lordship,
no.
we were not
Yes,
intimated.
you start.
It's not about.
You
It's
start.
not about her intimation. You are not followed my word.
I said the list is a notice
Start.
to the opposite party.
Kindly takes this up next week, Lord.
No, in this way I cannot adjourn. When matter has been fixed a particular time,
So we were not aware that the matter
you
was
take
being
note,
lordship.
you take note of his submission, I will see.
Lord, I have substantially argued
Also,
before your lordship,
don't
Lord.
be
This,
prejudiced, Lordship kindly takes this matter up next week.
You take note of it.
Lord, this is an proceeding. This is a quashing of a proceedings under section 498A. Lord, the petitioner's age is
Petitioner number 1 is sister-in-law and petitioner number 2 is husband.
Lord, yes. No, mother-in-law. Lord, I'm sorry, Lord. Are আমার brief টা
Sister number 1 is sister-in-law. Last talking
Lord.
you have said.
Yes, Lord. And the petitioner is 62 years of age.
Now petitioner number 1 is 59 years.
Now it is 67.
It is 67.
Yes. Your lordship has record. Taken a note, Lord.
How she became a 67? In your
voter card and all, Lord.
in your own course title you have mentioned the age.
Kindly give me a second. Come on. আমাকে এই briefটা দাও তো।
Srimati Suchitra Ghosh so and so
I'll
has
kind-
about 59 years. Within 1 year, you
Suchitra
become
Ghosh.
67.
No, Lord. Suchitra Ghosh, Lord, is 59.
Uh,
This petitioner number 2 is the husband.
66 years.
So that is the reason, Lord, I said 67. Lord, there is a long marital life. Lord, your lordship, Lord, would kindly recollect, Lord, that I have placed the affair before your lordship, Lord. This I said, Lord, at the instigation of the son who is a major, Lord, since I have refused to, Lord, give or extend, Lord, the financial support and, Lord, transfer the property in his name. Now that is the triggering point, Lord, when, Lord, this FIR was registered. Lord, on the last occasion, your lordship has also pointed it out that whether during the matrimonial knot for so long years, whether any complaint has been lodged or not, Lord, if your lordship so desires, Lord, I can place the FIR again, though I have placed the whole. This is a longish FIR, Lord, 7 pages FIR, which starts from page 61. Your lordship would kindly take note of, Lord, page 61 for a second, Lord.
Yes.
This is omnibus, no specific allegation with regard to, Lord, the cruelty. On the last occasion, Lord, I have also submitted before your lordship, Lord, the definition of cruelty. And two, Lord, I have also explained your lordship, Lord, that to attract section 498A, the definition which is enumerated in section 498A, that has to be substantiated. Now here, the sole allegation is harassment and torture, but the torture has not been explained to what extent, Lord. The torture, Lord, would be to that extent that she will be strived to commit, Lord, suicide. Lord, that's the, Lord, definition of cruelty, Lord, which is there in under section 498A. So, Lord, that the basic ingredients of the offense are, Lord, seriously lacking. And your lordship has also, Lord, pointed it out, Lord, since the marriage, Lord, took place, Lord, in 1995, and the complaint has been registered in 2021. What are the, whether there was any complaint lodged, Lord, to the for any act? No, there was no such complaint during this tenure from 1995 to 2021. Your lordship would kindly take, Lord, page 61 for a second, Lord. May I read, Lord, the FIR, Lord, the whole?
Yes, page 60.
Page 61.
Yes, 61.
Lord, I'm skipping over, Lord, the subject and all. That is only about, Lord, lodging of first information report and all. Now, Lord, the second paragraph onwards, the above named accused person number 1, namely such and such, is my husband, and we got married on 21/6/1995, following all the Hindu rites and custom. During the time of our marriage, the accused person number 1 has posed to be a gentleman, and his behavior had reflected the same. She admitted that, Lord. I'll just give a background, Lord, then I'll go into the details. But after this 498A was registered, before that, Lord, there are, Lord, since, Lord, is a long tenure of courts.
Since when you are residing separately, is there any award?
We are not blood residing separately, blood. She is residing in the same house, in a
Still,
different floor.
I'll come after my.
Blood, I did not say anything wrong, blood. I said in the same house on a different floor. And the house stands in my name. Though, Lord, I have purchased another property in her name, that she was when Lord, the marital note was fine and all, Lord, she was also Lord, looking after my business and all. But now, Lord, she says that when I took loan from the bank, she says that I have sold out her jewelries and then, Lord, I have purchased the flat. Now, there are many odd allegations. But what I am on, Lord, is this allegation.
when loan was taken, when
The marriage was before Lord, the FIR was registered. Before the FIR, she is a guarantor to the loan. And she is the principal borrower. Lord, it's not that, Lord, I have purchased it. The property was purchased in her name also. As I said, Lord,
if she is a principal borrower, how she became a guarantor?
No, I'm sorry. I am the guarantor. She is the principal borrower because the property was
Petition number
purchased.
two was the guarantor.
Lord, husband and wife, Lord, so Lord, loan is taken, Lord, to get the benefit of Lord, the government schemes and all, Lord, the ladies are always first, Lord.
Definitely. Yes.
Lord, your lordship would kindly.
So according to you, all the allegations are omnibus, vague, and there was no strained relations before
The marriage is
FIR.
And only after this
no ingredients has been
made out in the
under section 498A or 420 or 406.
420 blood cannot stand because of the reason. Lord, there has been the basic element of law is there has to be a initial deception. Lord, the husband and wife, if are doing something together, Lord, that even Lord partners, Lord 420, 406 does not 406 does not stand. Charge sheet has been submitted.
Under section, under
section, your lordship would kindly come to Lord the charge sheet, Lord, for a second, Lord. 498A. This starts from Lord page. Actually, 498A, 420, 406, read with section 34 Dowry Prohibition Act.
All sections has been.
Yes. Page 60. Page 67, Lord, is the
60.
No. 60 is the FIR. Don't make please. That is first information. Charge sheet is a different. 31st May 2022, Lord, the charge sheet was filed. All, Lord, so far, Lord, the investigation caused by Lord, the investigating agency, Lord, son statement has only been recorded, and other two, Lord, are the relatives of the Lord wife.
You have assaulted her.
No, Lord,
medical documents are also available.
Lord, there are.
The report is also available.
Lord, kindly consider, Lord, one aspect.
Why not 323 or 307 was given? Only 498.
Lord, I'll place before your lordship, Lord, how they have gradually, Lord, or exaggerated, Lord, the allegations. Lord, as I said, kindly consider, Lord, the age of the petitioner. He is 67 years of age.
So you are saying 66 years, a person cannot assault anyone.
I'm just coming.
Lord, as I said, Lord, because since inception, Lord, I'm saying in this particular case, the son, Lord, has started the moment, Lord, I have refused, Lord, to give money which to the son after selling out of my business, because I had a Lord, business establishment in central Calcutta. That too, my lord, a very lucrative business. I had to sell it out. But that money, since I have refused to give it to my son, the father, the wife, and the son has gone against me. Though they are staying in the same house, but they have taken out not only these allegations, but there are other FIR has been registered against me. There are counter cases. I have also registered few cases because they came and assaulted me. It's not that I have only
So you have been also assaulted.
I
by
have
her.
been also I have
You
by
have
this
been also
son
assaulted.
and the blood. I'm so unfortunate that at this age of 67, Lord, I had to fight with my wife and the son. Your Lordship would kindly take, Lord, there are in this particular 498 case, Lord, I'll come about the later proceedings also, Lord. Your Lordship would kindly take, Lord, page 68 and Lord 69.
The domestic violence case was also filed. Section 12.
Domestic violence 125. There are 447 other. I have also annexed all these documents. এটা my lord কে এটা দিয়ে দেবো আমাকে যেটা কপি দাও তো Lord, I have made a short list of dates, Lord. They are from Lord. I am going to Lord argue, Lord. Your Lordship would kindly take. ট্যাবে আছে কি ওদেরকে ওটা কপি দিতে হবে কিন্তু
Yes, anything else?
Lord, this is your Lordship would has seen Lord say page 68. The son ঝামেলা লেগেই থাকতো and then Lord, your Lordship would kindly see the last time. বাবাও আমার পিসি সাচানসাজ মাকে বুঝিয়ে সুঝিয়ে মায়ের থেকে অনেক টাকা নিজের ব্যাংক অ্যাকাউন্টে ট্রান্সফার করে নিয়েছে আমরা বর্তমান যে ফ্ল্যাটটিতে আছি সেটু মায়ের টাকা দিয়ে কেনা বাবা মাকে ভুল বুঝিয়ে মায়ের টাকা দিয়ে নিজের নামে এই ফ্ল্যাটটি কিনেছিল বাবা প্রায় সবসময় আমার পিসির কথা শুনে মায়ের সাথে Lordship would kindly see the son who is the best witness, a major son.
Raunak Roy.
My lord, a major son. What your Lordship would not find any basic element of 498. Basic. So far, the only qualifying word is cruelty. Now, your Lordship would kindly see this statement. Kindly. Not I'll place the whole. আপনাকে থানার তদন্তকারী অফিসার জেনে আপনার জিজ্ঞাসায় জানাচ্ছি যে মধুমিতা রায় আমার মা হয় আমার বাবার নাম রজত শুভ্র রায় আমি আমার জ্ঞান হওয়ার পর থেকে বাবা মায়ের সাথে ঝগড়া অশান্তি করতে দেখেছি দ্যাটস নট দি কোয়ালিফাইং ওয়ার্ড প্রায় সময় ওনাদের মধ্যে ঝামেলা লেগেই থাকতো এমনকি বাবা মাকে মারধরও করতো বাবা আমার পিসি সুচরিতা ঘোষ মাকে বুঝিয়ে সুঝিয়ে মায়ের থেকে অনেক টাকা নিজের মাকে বুঝিয়ে সুঝিয়ে অনেক টাকা নিয়েছে দ্যাটস নট দি ডেফিনেশন অফ ডিমান্ড অফ ডাউরি ব্যাংক অ্যাকাউন্টে ট্রান্সফার করে নিয়েছে আমার বর্তমান যে ফ্ল্যাটটিতে আছি সেটিও মায়ের টাকা দিয়ে কেনা বাবা মাকে ভুলভাল বুঝিয়ে মায়ের টাকা নিয়ে নিজের নামে ফ্ল্যাটটি কিনেছিল বাবা প্রায় সময় আমার পিসির কথা শুনে মায়ের সাথে ঝামেলা করতো আমার এইসব ঝগড়া অশান্তি ভালো লাগে না আমি চাই বাবা পিসি তাদের কর্মের সাজা পাক what now I can read section 498 the son who is accompanying what would his age is on that date when he recorded this statement is around 24 years but he does not disclose anything. Now, your Lordship would kindly take the next page, page 69. The sister of the complainant, being the mother of the earlier statement maker. অত্যাচার করতো কি অত্যাচার করতো বলে that has not been spelled and it's all about money. Now I being a businessman that I have not taken any money from her.
Who is Rajiv Pal?
The younger brother.
Younger brother.
Now, based on these statements, a charge sheet is filed against me under section 498. I'm not so far, blood 498 and 420 is concerned. That cannot run together also. Now, therefrom, your lordship would kindly appreciate
Most of the allegation that the petitioner number 2 has purchased the flat of the money of her wife, his wife.
Blood, as I said, blood, some money came from my business, some money came from my wife, and the rest of the money I have taken loan from the bank. But she is also, blood, a party. It's not that I have purchased the property in my name only, or I have thereafter
have you annexed those documents?
Lord, I have sought leave, Lord, on the last occasion from your lordship, Lord. There are, Lord, those documents. It has been served to them through virtually. Hopefully, you have received. Your advocate has received. Lord, there, Lord, is the supplementary affidavit where, Lord, I have annexed. Your lordship was also looking those documents on the last occasion. And Lord, the trade license which was obtained, Lord, for doing a business in the same building, that was also containing her name. Now, subsequently, see, after registering of all these cases,
where you have annexed the property details and the loan amount.
I'll just come, Lord. Page 23, your lordship would kindly come. A2. Kindly take note, Lord, this is a sanction ticket number such and such. Then, Lord, Madhubita Pal, borrower, and Mr. Rajat Subra Rai, co-borrower. So, we both are borrower. So, it's not that the property was purchased in my name. She was also, and till date, Lord, I just must point it out before your lordship. Till date, I am paying, Lord, the EMIs. It's not that, Lord, the opposite party has paid any time, Lord, the EMIs. I am paying, Lord, the EMIs, and this is being remitted to the loan account from my account.
Where is that?
Your lordship would kindly, Lord, may I just place, Lord, the other documents for a second? Loan document
Yes, place that document whether you are paying or not.
Bank statement to amar kache. You can come and satisfy the court.
We have not annexed that.
Lord, I'm sorry, Lord, I really could not. But the sole contention.
Because the allegation is that you have taken her money and purchased the flat in your name.
As I said, Lord,
you have said you are submitting without any base or
Lord,
without
one document, Lord, I could produce before your lordship, Lord, that it's not the thing that, Lord, the property was purchased from her money. The property was purchased, Lord, after taking a loan. The loan document contains, Lord, the name of the both. Now, Lord, I can, latest stage, Lord, I can definitely, Lord, produce the bank statement.
Anything else? Do you want to rely any judgment?
Lord, I will. Lord, your lordship would kindly allow me, Lord, few other things, Lord. There are, Lord, complaint lodged, Lord, subsequently to the, because it was a running business. Lord, there in that particular building, Lord, which my learned friend's client has stated that I have purchased the property in my name and then I have misappropriated it. Her name was also recorded in the, Lord.
That's why 420 and 406 they have.
Now, Lord, I say, Lord,
they have
incorporated. Husband cannot be said to have committed an offense of 420. And 406, so far the issue with regard to Sridhan article, I could not have argued. But so far, the property is concerned, Lord, there I say that the element of 406 in the context of, Lord, the complaint which has been registered does not stand, because the property was purchased in the name of the husband and wife and still they are joint owners of the property. There is no allegations and neither there has been any Lord, evidence to the extent, or Lord, there is no investigation to that extent, whether I have sold it out or not. I have not sold it out, and she could have been
How you can sell the
Lord,
property?
my portion, my portion. I have not done it. On the contrary, Lord, I proposed that I want to give the whole property to you. They have not accepted.
Proposes for settlement.
Lord, I want peace in life at the age of Lord 69. Who wants to Lord face a proceedings under section 498A? That too, Lord, why?
Yes, what is your
That
instructions?
that was not Lord Mr. Mukherjee.
Instructions and
Mr. Lord, I have directly proposed to Mr. Mohit Mukherjee, but it was refused by their client. Lord, I was always agreeing. Lord, I requested Mr. Mukherjee, let's go to mediation and then resolve it. We will not take the burden as a lawyers. He said, no, my client do not want. My client want to proceed with the case. Mr. Mukherjee said, Lord, I had a talk with him on number of occasions.
No problem.
Her senior, Mr. Mohit Mukherjee. Now, Lord, I have also registered a case against Lord, as a counter and all. Lord, ultimately, Lord, that case was quashed by this honorable court. Lord, I have also annexed that in the.
Your case has been quashed.
Yes, Lord.
In the supplementary affidavit.
No. In the main petition, Lord, I have annexed the order. But I'm losing everywhere. I'm losing the family. I'm losing my life. I'm losing my money. I'm losing my assets. Lord, I don't want to lose anymore.
Yes.
Lord, page 132, your Lordship would kindly come.
132.
No?
Yes, 132.
P16, it's not matching. That's the reason.
Where is the quashing order?
Not I guess. 138, Lord. মিস হচ্ছে গো, আমার কোথাও একটা দুটো পেজ মিস হয়েছে, আমিও আগের দিন দেখতে গিয়ে শিওর কাইন্ডলি গিভ মি আ সেকেন্ড লর্ড
130 is just admission order.
না দ্যাট ইজ নট দি থিং, ওদের যে ওয়াশিংটা ইয়ে হলো আমার এখানে গন্ডগোল আছে, পেজের গন্ডগোল আছে, কাইন্ডলি গিভ মি আ সেকেন্ড লর্ড এইটা Page 41 of the supplementary affidavit, Lord. I'll show few other documents, Lord. I beseech your Lordship, Lord, to kindly hear me because page 41 your Lordship has got, Lord.
Yes.
This was a complaint lodged by me. It says petitioner number 1 is the son, petitioner number 2 is the wife of the de facto complainant, opposite party number 2, who are residing in the respective floors of the same building. Now, Lord, I just wanted to bring the fact before this honorable court. Your Lordship would kindly. This has been quashed, Lord. I'm not on the Lord observations, Lord. I'm not on the Lord finding of this honorable court. I am on that the parties, Lord, are litigating between themselves. Lord, your Lordship would kindly come to the previous page for a second. Lord, may I just ওইটা এই ট্রেড লাইস ব্যবসাটা যখন বন্ধ করতে হলো এনকেডি এর এটা পেজ 38 না লিস্ট অফ ডেটসটা বের বিমান তোমার ট্যাবে লিস্ট অফ ডেটস হয় তো
Yes.
Kindly come to page 38 for a second.
38.
And kindly see the top. Who is the writ petitioner? The de facto complainant. And what is the content? Your Lordship would kindly see, Lord. Petitioner is aggrieved by the guest house which is being run without any proper documentation. Petitioner is aggrieved that the police authorities have not taken any steps. Attention of the court has been drawn to the communication made to the administrative officer NKDA dated 12/3/2024. Now the trade license was also in her name. And now she, after registration of the FIR, that if I am, why I am placing this before your Lordship, that if I am running a business, that why do I take money from my wife? Because financially, with greatest humility, Lord, I say that I am on a better financial I'm carrying a better financial status than my son and wife. And that is the reason, Lord, they have foisted these criminal cases against me. Only to grab the money. Now, Lord, your Lordship would kindly see. In all sphere of life, Lord, mentally, physically, socially, and legally, I am being targeted so that I bend down to them and give my entire assets. Now, as I said, Mr. Mukherjee has come. I have said that I'll give half of my property to mother and father, son. After I die, you will get the whole. But I want to die peacefully. However, Mr. Mukherjee's client did not turn up on that proposal also. The sole contention was that I don't want to fight anymore. I have my legal rights to contest the proceedings, but I don't want to die in suffering. I don't want to die in peace. So, your Lordship would
So
kindly.
what you can do if your other side is not ready to settle the matter?
No, it's not. As I said, Lord, they are claiming money. It's the whole context is Your Lordship has seen in a 498 proceedings. Your Lordship has seen this statement. Lord, there are plethora of judgments of the Honorable Supreme Court. Your Lordship has also delivered judgments to the extent that there has to be an incident. In a particular incident, there has to be date, time, and the incident has to be narrated, which has to be proved by the other cogent evidences. Now, here your Lordship will get the statements made by all the witnesses, the three witnesses which has been examined during the course of investigation. They all talk about money. In the complaint, there are alleged incident which says mental torture, physical abuse. But
okay, would you like to refer any judgment to your refer?
Lord, I shall, Lord.
So I conclude. You have already given, I think, compilation.
Yes, Lord. These are the Lord. But I wanted to Lord argue on the judgments.
Lots of judgment you have referred.
There are few blood. These are all in the same line and quote, Lord, that there has to be a specific allegation. Omnibus allegation.
So altogether 16 judgment you have referred.
Lord, these are Lord, normally the judgments which I cite, Lord, in all 498 cases, Lord. And here also, Lord, the FIR and charge sheet, Lord, if you Lordship look, Lord, together, that really does not make out a case. Lord, it is all about the monetary claim.
Okay, you are concluding now.
Lord, if your Lordship is, Lord,
আমি কি একটা কপি অফ দ্য
কিসের?
সাপ্লিমেন্টারি
দিয়েছি ভাই ডিজিটালটা দেখিয়ে দাও
supplementary affidavit which
Mr.
they have relied
Mukherjee,
upon.
don't say anything. I do not say anything.
No, I did not have it right now.
My advocate on record has sent it to your junior electronically. Hard copy chai? Your client is rich. I'll give him a copy.
Hard copy একটা দাও, supplementary affidavit.
I'll give him a copy.
Supplementary
Here and now.
affidavit filed by the petitioner your CD. You have to go through it and next day you CD টা দিয়ে দিন।
সে তো বললাম রিপিটিশনের কপিটা তো
Bring the CD next day. Yes, what about any investigation during investigation? The statement is nothing. Apart from that, I have seen from the charge sheet that medical document and injury report was collected. Whether that is available in CD? Nothing.
But if there is no, then my lord, what
The
can I?
CD does not reflect.
15th of November, this lady was assaulted. 18th of November, case was started. My lord, if there's an injury report which has been collected by the investigating officer, my lord, should be a part of the case diary.
So that will reflect.
Should be a part of the.
I was assaulted, not the lady.
Oh, my lord, my lord, senior's client, my lord, is as if
I said
some
not.
kind of a
No,
reincarnation of God. My lord.
He is not.
That is what I.
He is
cannot
not.
believe.
But he has a right to
Some-
die in peace. So
Some
that's what
reincarnation of God, my lord, who is now
I
between
said,
some
Lord,
kind of.
Okay, I will see. the
realization
record.
may come late. But
Rely on your.
I said I can sacrifice my half of the
Listen,
property.
I have to
can.
go
I
through
want
the
to die
record.
peace.
Yes, ma'am. Lordship, I will place my.
And tally with the submission with the record.
Obliged. I'll also, Lord, I'll bring, Lord, that document that I'm paying, Lord, the EMIs still date. Lord, I'll bring that document. Obliged.
Deeply.
You next. So I will fix at the particular time.
12 o'clock.
12:30 করে দেবেন, হ্যাঁ? 12:30.
Lord, in
Yes.
item number 24, I am on the behalf of the respondent. In this matter, they have filed order 39 rule 2A.
1 minute. 24.
Yes, ma'am. I'm for the respondent in this matter.
Nobody is there from the side of petitioner.
What is the plea? My lord, they have filed the wrong application. They have filed order 39 rule 2A, which is applicable under order 43. They have filed under 227, my lord. That is not maintainable.
Nobody is there, so I am adjourning today. Next day you submit. None appears on behalf of the petitioner.
My lord, item number 40, my lord, a cranny is appearing, my lord, it's for extension of interim audit. May be placed any day under the heading extension, my lord. Item number 40, today's list, my lord.
40.
40.
Take up on the main application. I think there is no possibility. There are 8 or 9 matters are there. May not be sit, but if adjusted, I will come.
My lord will not sit on second half.
Second half division bench is there.
Great.
আছে এখানে আছে আছে? লাগবে না লাগবে না yes
My lord, be taking the
serially 24
is it 2:30 p.m.
2:30
My lord, item number 77 and 78, my lords.
take up 24 দেখি লিস্ট দেখি এয়ার গুলো নেই ask them to come বুঝছো তো ঠিক আছে
I appear for opposite party number 2, the caveator.
nobody is there
Not maintainable.
nobody
It's an
is
applicable
there
order.
applicable order
Yes, my lord. Order 43. My lord, kindly come to order. Done. My lord, order 43, rule 1, sub rule R.
No, this order is regarding rejection of injunction.
Yeah, injunction. And my lord, kindly come to the provision, my lord. Appeal from order. Order 43. Rule 1, my lord, sub rule R. Rule, sub rule R.
R. 39 rule 10.
Yes, my lord. 39 1 and 2.
39 1 and 2, rule 4.
And this is again rejection of 39 1 2.
The petitioner is not there. Last occasion also not there, no?
If it is not maintainable, then what will he argue? My lord? I am showing from the provision.
কোথায়? ইয়ারই নেই।
I am appearing for the petition.
You are for the petition.
My lord, I was under the impression that your lordship would not sit on the second half. So,
How you can make an impression?
my lord, because your lordship said that your lordship has had a division bench.
Division bench, but
That-
I also said that after adjust.
After the division bench, my lord, I did not.
If
I did
division
not.
bench adjust, why should I not sit?
Yes, my lord.
Yes. What is your case?
My lord,
You have come here against the order of rejection of injunction
yes,
in
my lord.
appeal.
Yes, my lord.
So you have a provision to challenge that order under appeal.
Yes, my lord.
Why you have come under
My
revision?
lord, my lord, if I state the facts briefly first, because my lord,
It is
my
law. You challenge this order in law, appeal.
yes, my lord. In appeal, I have challenged that order, my lord.
Not maintainable.
My lord, no, it is maintainable, my lord.
How?
Because this is the appeal which was which is pending before the appellate court, my lord. There I have filed the injunction application. My lord, that injunction application was dismissed.
So that is also 39 rule 1 and 2.
Yes, my lord.
So
but revision is maintainable, my lord.
How?
Revision is maintainable, my lord.
How,
That is
how? When there
because
when there is a specific provision for appeal from orders.
yes, my lord, appeal from orders, there is a specific provision, but in cases of suits only. Not in cases of, because, my lord, the title suit which was pending before the trial court, that title suit was dismissed on the ground that we have not paid for recovery of possession. Now, once that suit got dismissed, I filed an appeal against that decree, judgment and decree. When I filed an appeal against that judgment and decree, my lord, in connection to that appeal, my lord, I also filed an injunction application. So, my lord, that
suit is continuation of
yes, my lord. Suit is the no doubt about that. Suit is the yes, my lord.
Similarly, section 39 rule 1 and 2 you have asked for, and your prayer was rejected. You see, go through the.
My lord, otherwise, yes, my lord, I have the CPC with me. I have the CPC. Order 43.
Where is the provision? Even if there is an appeal provision, you can ask
My
for.
lord, there is no direct provision, but there are judgments as well, my lord.
Is that
Say,
so?
but then I have to. I did not anticipate that your lordship would
Why
get into this question.
You must be prepared.
I must have
for
been
every
prepared.
angle.
Yes, my lord.
Any question can be put to.
Yes, my lord. Any question can be put by your lordship. I have to answer that question, my lord. Certainly, I have to answer that question. But today, I am not prepared with that question, my lord.
No. Do you have any judgment?
Yes, my lord. There is a judgment.
Where is that?
There is a judgment. I have not bought that judgment right now. I don't have. I'm not armed with that judgment right now.
Yes. Do you have any?
In respect of the order granting refusal, we have lordship judgment. We are carrying the judgment. Regarding maintainability of the revisional application, if your lordship wishes, lordship on the next date, we can lordship counter their submission.
He is saying there is provision or there is judgment. Where revision is maintainable even if there is a provision of appeal.
appeal.
Yes, my lord.
On the face of the record, lordship, it is statutory appeal is there. They have to prepare the statutory appeal. If lordship they want to satisfy the court that there is civil revision will lie lordship under 227.
Okay.
Let them argue first lordship on the point. Then lordship will.
Yes.
ফিক্সড ম্যাটারটা দেবে না 230 তে আছে ম্যাটার 230 230 তে ম্যাটার আছে
30
27 and 78 both are.
77, 78, my lord. I am led by Mr. Bhattacharya, my lord. It is for my learned friends to commence their submissions to them.
Yes, I have already concluded submissions from your side.
Yes.
This is regarding the matter
But
pending before the Supreme
Yes,
Court.
sir. My lord, the essence of the, what is that?
চলবে তো?
The essence of my learned friend's argument has been that, without going into the merits, that this particular issue, which pertains to rate circulars of the railways, before the Supreme Court, and a bunch of matters which is based on the constitutionality of the rate circular has been challenged, which originally emanated from the Calcutta High Court. Calcutta High Court upheld the virus of that notification, rate circular. Division
Upheld
bench
the virus. Upheld the notification.
Upheld the notification. Division bench upheld the notification. It went before the Supreme Court. Supreme Court has taken all the matters from different places of the country and kept it and said that there will be a stay of these matters. Further, no further proceedings. Now they are saying that is because that particular rate circular has been challenged. Now what my endeavor will be before my lord is our case. They have tried to show that this case relates to only the rate circular. My endeavor would be before your lordship to show whether this relates to only the rate circular or any other things.
Even if other things is involved, rate circular if involved, then how you can proceed other until and unless rate circular is
No, my lord will also have to
the
consider.
issue with regard to rate circular is pending. That is the question.
In that sphere, my lord, I will say that even if the rate circular is pending, there is a stay with regard to rate circular event, which includes of 2009. The rate circular of 2009 is the rate circular that has been challenged.
When there are two rate circular,
Now,
subsequent also.
Yeah, 8.
Okay.
There is 8 and prior, on the basis of which this FIR, my lord will kindly appreciate, the FIR is for events between 2008 to 2011. Now, obviously, the rate circular that is there of 2009 would not be applicable for the events of 2008 onwards.
But the incident which was taken place after 2009, 10 and 11.
Partially. Now, that is not just the only case which my lord will have to see. The repercussions of the stay that has happened before, that has been passed by my lords, which was in 2003. The ML case, the complaint was filed in 2023. 2nd May, my lord. My lord, kindly take this date. 2nd May, the ML case was filed.
And on 10th May, they got an ex parte stay from you. Now, the ML case that was filed, specifically, the rate circular events have been discussed, and at paragraph 12 of that ML complaint, it has been specifically said that the investigation are further going on and we need to file supplementary charge sheets, complaint. Now, the fallout of this what has happened is from 2003 to 2023 to 2026, we could not proceed with any investigation with regard to the other part.
What was the date? The ML
2nd May, the
2nd May
case was filed.
2nd May 2023.
2nd May. 10th May, an order was passed from here, my lord, ex parte order of stay, which is still persisting and going on. So now, in that ML case, we had specifically prayed at paragraph 12 that
This ML case arises out of the notification.
Out of the scheduled offense, which was committed between 2008 to
2011 and emanated from the notification of 2008.
Emanated partially 2008
and
partially
2009.
And the 2009 rate circular is challenged and pending before the Supreme Court. Although
2009 is pending before the Supreme Court.
2009 is pending before the Supreme Court has, without going into the merits of it, has assimilated all the challenges that have been on that particular.
So even if partly a case is involved in this ML case, even then you cannot proceed until and unless that was decided.
Then my lord will have to see the PMLA offences is a completely independent inquiry, independent investigation. Now, the
Your MLA case is based on the rate circular.
No,
partially of 2008 and partially with regard to 2009. Because your cause of action arose when
2008.
2008. You cannot raise any question or lodge any questions after 2009.
I can. Why? Because this case.
You have lodged this case in the year 2023.
I have lodged in 2020.
23. So you can lodge no problem 2008 to 2011.
Yes.
But there are two circulars.
There are two circulars.
There were two circulars.
Yes. Now
both circular are involved in your
both
case.
circulars are involved in this case.
With regard to the rate or terms and condition, whatever they have violated.
Correct. Correct.
So how you can proceed if one case is stay in the Supreme Court? Can you bifurcate your FIR?
That will be now my FIR. I can't bifurcate the FIR because mine is a complaint.
Complaint.
Mine is a complaint.
Even if
FIR
complaint,
is of the CBI.
even if complaint, can you bifurcate and punish?
No, I'm not bifurcating. Not bifurcating. My lord, the rate circular is one of the issues. Whether 8 or 9, for a moment, my lord forgets.
But rate circular is involved in this case.
Rate circular is definitely involved of 2009, of which my lord knows that once the virus is upheld, it is taken as if that circular is there.
No, Supreme Court has
not.
Stay that.
No.
Stay was granted.
Supreme Court has not stayed the circular. Supreme Court has not stayed the circular. Supreme Court has stayed the proceedings. The proceedings that are emanating from that particular FIR. Those cases.
So those cases then.
So therefore, the circular remains there. And there are plethora of judgments on that. Once the virus is upheld by a particular court, till it is overturned by a superior court, that rate circular will continue. That particular rate circular will continue. The number of judgments I can bring before my lord, all the judgments on that. No, my submissions are not just on that. My submissions are that rate circular consists only a part of the complaint of the offense. Of the scheduled offense, rate circular only is one part of it. Now, today, my lord, my endeavor is the other two parts are one, illegally constructing private railway line. That is completely different from this. The sections are different. The proceeds of crime emanating from this are different.
No, private railway line means
Illegally constructing private railway line. The railway sidings had been made. Railway sidings that they have been made, they have been done illegally in cahoots with a railway official who is also one of the accused in the predicate offense. The second is forgery to get more rakes. Forgery to get more rakes. So these are scheduled offences without involvement of any rate circular. Third is rate circular. Third is the rate circular, which is the rate circular of 2009. The subject matter
pending before the Supreme Court.
Subject matter pending before the Supreme Court is 2009. Again, my lord will kindly consider the rate circular is not stayed. So the particular proceedings emanating from these cases will be stayed for the moment. My lord, I will show that order.
I am asking you a simple question. When any case emanated from rate circular of 2009 is pending before the Supreme Court, pending before the Supreme Court,
on the point of
whether that is that's rate
constitutional or
circular
not.
would be
Constitutional or not.
or not.
Now,
Other proceeding pending relating to rate circular or relating to rate circular are state.
What is stayed again is these proceedings relating to the rate circular of 2009. My humble submission before my lord.
Please tell me what is the rate circular.
Before, yes, kindly comes to the rate circular. My lord will kindly take the supplementary affidavit, page 907. What supplementary? Volume 5, supplementary affidavit. Volume 5, supplementary? No, volume 5. Volume 5.
Volume গুলো কোথায় আছে?
Page 1, my lord, page 1. My lord, revision application, page 161 of volume 1. Your kindly takes volume 1.
Which one you are referring?
Volume 1. Volume 1.
No, 1765.
161. Page 161 of volume 1 of the revision.
161.
One CRR 1765.
161.
Page 161.
161. Yes. Rate circular 36 of 2009.
Right, my lord. Now kindly see rate circular. It's written above. Rate circular number 36 of 2009. My lord has found it.
Yes.
Now they kindly sees the date 1st June 2009. Now kindly sees
this circular was withdrawn.
Yes.
Yes.
It is withdrawn.
My lord will kindly.
Which is why it cannot be stayed, my lord. Withdrawn thing, how can that be stayed?
So then everything is fine. Nothing is pending before Supreme Court. If withdrawn, nothing is pending, then there is nothing to be concerned about.
When it was in vogue, that was challenged. The moment we challenged, they have
I-
withdrawn.
I am asking you, their submission was that it was withdrawn on 9th May 2016.
My lord, I didn't get.
This circular was withdrawn on 9th May 2016. Whether is it correct or
16 operation was only operation was 2016.
till when?
Now, my lord, kindly see, during the particular time, the rate circular was in vogue. Now, subsequently, if it has been policy changes. So, whether in 2016,
I am asking you whether this is still exist or withdrawn.
presently there is a different policy. Oh, question when a new policy comes in, obviously the earlier policy.
The simple answer is it's not in
My
operation.
lord, if this is the way if we operate, then I will not be able to answer. If he says something, I
No, I'm just asking.
No, what I don't want. Let me finish. And
I am asking him, he will answer, no problem.
Yes, ma'am.
If he unable to answer, I will
Then
ask.
finally we will, my lord, assist,
Of
give
course,
our reply.
Of course. My lord's question is, my lord's,
So this circular was withdrawn.
my lord, I will kind. When the policy comes, when a circular or notification, rules, etc., that comes based on a policy of the government. Here in this case, it was a railway policy that there would be such and such thing for domestic rates, such and such thing for export and other rates. Now, in such a situation, circular has come in, which is applicable on to all who fall within the purview of those. During a time when these circulars were on, during the time when these were applicable, at that time, there are certain events that happen. I would say not even crime. I would say certain events that are happening, which are in contravention of that particular circular at that time. Now, whether in 2015 or 16 or 14 or 13, whether that rate circular has been withdrawn or a new policy. It really is immaterial. Although it has happened in
According to your submission, at that point of time, they have violated the terms and condition of the circular. And for that reason, you have initiated a proceeding against them.
Not just that.
Apart from that, there were other allegations.
Very, very important and very serious allegations against them, which involved certain high officials of the railways also. Which is why CBI came in. Upon CBI's investigation, FIR was filed. Subsequently, this FIR was of the CBI. Charge sheet had been, there's an order of the Supreme Court that these charge sheet will be filed upon without
permission of the Supreme.
In that, there was a subsequent FIR.
Ultimately, CBI case was stayed.
CBI case as of now is
Stayed.
Right. Now,
proceed of crime of that CBI case, you have initiated a ED case.
this is an independent offense, as my lord knows that this is an independent offense. Now, there has to be a quietus somewhere when that quietus will come in. When an investigation is completed on the score of the PMLA. Now, what has been, the machinations have been used in such a manner that when
if CBI case goes, what would be the result of this case?
That hasn't gone.
Suppose in case
Well, Vijay Madanlal has specified
categorically
under what
stated under what situation this case.
This event doesn't fall under that as of now. So, my lord, it is my duty to investigate.
Main case is state. Then why this subsequent case?
When did I investigate? The question of question of arguments, judgment, adjudication of those cases come later after investigation. Today, for example, my
So
lord.
investigation is not a proceeding.
So what I am saying is, if I can't investigate today,
Then what does it mean by the proceeding? What
that
proceeding?
even Supreme Court has passed an order, my lord, where Supreme Court has allowed the CBI to continue with the investigation and file the charge sheet only after leave of the Supreme Court. So,
So investigation is going on.
yes, investigation.
Similarly,
But in
what
our
is the,
case, we are not getting that.
what is the status of this case?
This case,
Stayed.
2023, 2nd May, I filed a complaint case. 10th May, there is a stay. 10th May, there is a stay. 11th May, 2023, there is a stay, and that stay has been
Did you file any application for vacating of the stay?
No, my lord. Thereafter, we have been at every
So
point
you
of
are
time.
not interested at all.
My lord has been facing from
Because
such a long time. My lord.
2023 the matter was filed. Now 2026.
No,
You
my lord,
are
I have been almost every other occasion. My lord knows I have been trying to.
at least you should have filed the application for vacating so that you can continue your investigation. You did not file.
My lord, at some point of time, it was my lord's pleasure that if there question.
Now the question is here whether this proceeding will be continue or not. As per the submissions made by the petitioner that the similar matter was pending before the Supreme Court and all proceeding has been stayed. Similarly, other proceeding in this High Court is also stayed. That is also they have filed some judgments.
No, that is of
Judgments
a different.
are order.
That is not got. It is not connected with this.
That is another case.
No. This is this case.
In this case also you have filed
My lord,
coordinate
there is
bench,
one.
coordinate bench
My lord.
of another
Yes, my lord.
cases.
My lord, another thing, my lord, there is a slight mistake with his leave, my lord. I don't want to really come in between. My lord, he has said that immediately after the filing or starting of the case by the ED in the month of May, on 10th May, there was an order of expertise order of stay. The answer is no. Because it was on 11th and Mr. Kundulia himself submitted on that day.
No,
The order records.
The order.
My lord, the order is very illustrative and it is there with your lordship. Your lordship shall find it. He had basically tried
Whatever may be, still stay is
Yes.
there. Until and unless
also
stay
effective to say is
vacated,
there.
he cannot proceed.
Yes.
Absolutely.
Or ED cannot proceed.
Won't proceed. I haven't been.
Cannot proceed even today.
Even
because the situation
now
has
the
not
question is here whether this stay will continue till the pending of the
What
Supreme
fell
Court
from your
case
lordship?
or this will be continued.
What
That
fell
is the-
from your lordship was that, my lord, we said that since this is already that there are several other matters similarly placed which is relating to the same red circular, my lord, since they are also stayed till the disposal or till something happens in Supreme Court, my lord, let there be a stay till until further orders, because unnecessary every time we are coming seeking for extension. So that is what actually fell from your lordship, that I'm not going to get into the merit, but I want to see whether this particular case has any bearing or any connection with this red circular or those cases which are there before. If it is,
now
then
the
your lordship
question
shall proceed,
is here,
or else, my
this
lord,
case involve partly the red circular of 2009.
My lord.
And as per your submission, this was withdrawn.
My lord.
As per his submission, it is still continuing.
Kindly see page 872.
My lord, the words are really.
Allow me to complete.
Yes.
None of
Definitely. My lord. Let him complete, we shall answer.
My lord, let me clarify my lord's mind on the question of withdrawal of the rate circular. ওটা দেখান তো পেজ ভলিউম 5 দিন পেজ 872
ভলিউম গুলো আলাদা রাখা আছে, দেখুন না কোথায় আছে।
ভলিউম 5 দিন পেজ 872
হ্যাঁ তো দিন,
মামলা চলছে, আপনি রেখে দিলে কি করে?
আপনাকে তো ভলিউম বলা হচ্ছে 5 নম্বর, আপনি আমার মুখ তাকিয়ে আছেন।
My lord, may I hand over the tab? It will be.
No, there is already volumes. 1765. 1765.
1765.
Both are similar matter, no?
Both are same. Right.
So according to you, this is still exists. This circular.
No. My lord, kindly seize that document, page 872.
দিন ভলিউম দিন না ভলিউম কত নম্বর আছে লেখা আছে তো এখানে ভলিউম ইউ আর আস্কিং ভলিউম 5
Page 872.
supplementary
Main revision, volume 5.
volume 5
There have been so many documents that have been filed and different.
শুনে দেখুন না ভলিউম 4
My lord, maybe assist my lord in finding the documents.
8
My lord has got
Yes,
volume
yes,
5,
yes.
page 872. My lord, this is the,
yes 872
my lord, you see, my lord sees the date,
9
9/5
May
2016.
Hmm.
So this is when this circular was superseded. The earliest circular of 2009 was superseded by this circular. My lord, may I read this? In supersession of rate circular number 36 of 2009.
supersession means already that earlier one
Yes.
one was revoked
In 2017.
2016
Policy changes in 2016. my lord,
16,
16.
yes.
In supersession of rate circular number 36 of 2009, amended from time to time, sanction of the central government is hereby accorded to the following. The dual freight policy applicable for transportation of iron ore and iron ore pellets is discontinued. So this is discontinued. All types of iron ore and iron ore pellets, whether meant for domestic consumption for manufacture of iron and steel, as well as cement, or meant for other than domestic consumption, will now be charged at class 165. Next line is important, my lord.
This is your
These instructions will come into
the
force
second one is involved in your case. Second one is involved in your
2009.
case.
The one we are talking
All
about.
types of iron or iron
Yes,
or
yes,
pellets, whether
yes,
meant
yes,
for
yes.
domestic
Yes,
consumption
correct.
is the
Absolute.
so this is applicable to you.
So this changes. The new policy comes in only in 2016. My lord, sees paragraph 2.
So here the charge has been changed as class 165 train load.
Correct. my lord.
Where is that?
No, I'm coming to that. This is, my lord, can you see this date is 2016, my lord has seen. Now sees paragraph 2. These instructions will come into force with effect from 10th May 2016 and remain in operation till 31/3/2017. So this is a completely prospective circular that has come in for a particular period again. So this circular has no impact whatsoever in the earlier when the policy was on. This
So there is no retrospective effect.
retrospective effect. No, only and that too this comes in for a period, specified period of 10/5/2016 to 31/3/2017. That's all, my lord. That's all. What they are talking about withdrawal and all that. There has not been any withdrawal ever.
So whatever you have taken you have taken the complaint on the basis of earlier notification is still exists.
Still exists. The crime which we are saying
are still there.
Was always there. FIR was of that time. The crime continued. It's not that after a particular today, for example, a certain thing statutorily, if it's a crime, even tomorrow, if that particular act changes, this crime remains.
Now, please come to the Supreme Court. Which order you are relying and which matter is pending? The class 165 is here. Annex? No.
I'll show. My lord will. That I will show the rate circular. My lord sees both the rate circulars, 2008 and 2009 one. I'll come to 2008 first and then 2009.
No, from this circular or supersession of earlier one, this was brought into effect. So earlier was already over.
Earlier was already only in 2016 that earlier circular was amended.
Revoked and amended.
Not revoked. In supersession of that earlier circular, prospectively for a
particular period.
For a particular period, this was.
So whatever allegation as per the 2008 and 2009 is still
remain.
There is no doubt.
No doubt about it. My lord, now kindly comes one allows me to show rate circular 2008 once. Rate 165. Supplementary volume 5 টা দিন।
দেখুন সাপ্লিমেন্টারি লেখা আছে ভলিউম 5।
Supplementary affidavit 870. এগারোটা ভলিউমের একটা সাপ্লিমেন্টারি অ্যাফিডেভিট দিয়েছে সেটা
সব মধ্যে লেখা আছে তো সাপ্লিমেন্ট
5 নম্বর এইটা দেখুন এইটা পাঠিয়েছিল তোকে দেয়নি তোকে দেয়নি না I'm sorry, my learned friend herself doesn't have those. Otherwise, I will get help from her.
আরে লেখা আছে সাপ্লিমেন্টারি
আমার কাছে এইটা
873 সেলফি ফাইল করে এটা
সেকেন্ড সাপ্লিমেন্টারি
পাঁচটা 873 আছে
না না
এই মামলাটা এইরকম সাজিয়ে রাখতে হবে all documents have to be kept like this.
Yes. Page number?
My lord will kindly see 873. My lord has it, my lord?
Yes.
My lord will kindly see at the top, rate circular number 24 of 2008. Now, my lord sees the relevant parts I'll place. Page 874, 3, Roman 3. To revise, my lord has it, to revise the classification of iron ores for other than domestic concern.
You are referring
Page 874.
Paragraph 3.
3.
Instruction issued by railway.
No. My lord, the Roman 3. Above.
Roman
Second,
3, yes.
second paragraph from the top.
Yes.
to revise the classification of iron ores for other than domestic consumption under the main commodity head mineral and ores from class 180 to a new class called class 200X for both train load and wagon load movement. And then my lord sees paragraph 4. The classification of iron ore destined for domestic consumption is class 170. So now it becomes 200X or 170. Now my lord will kindly come to the next page. Accordingly, following footnote should be inserted below the commodity head, mineral and ores at serial number so and so. Iron ore domestic will be charged at class 170 and iron ore for other than domestic consumption will be charged at 200X. So iron ore domestic is 170, everything else is 200X. So this is the this is the relevant paragraph in the rate circular. Now again, my lord will see 2009, which is at volume 1 of the main petition, page 161, which I was showing, my lord. In the beginning, I started with that.
Volume 1.
Volume 1 of the writ petition of the
Revision, yes. Page number
161.
Yes, 161. Yes.
Where we can see classification of iron ore in supersession of rate circular number 24 and 30 of 2008
and 2009
and 25 and 34 of 2009. Sanction of the central government hereby accorded to the following. Iron ore will be charged at class 180 for train load movement. Besides following, distance-based charge will be levied on the traffic. Now, my lord, my lord will see number 2, paragraph 2. Notwithstanding paragraph 1 above, traffic of iron ore meant for domestic consumption for manufacture of iron and steel as well as cement will be charged at class 180 without levy of distance-based charge prescribed in para 1 above, subject to fulfillment of conditions laid down in para 3 of this circular. So now domestic is 180. Now kindly comes to page 1.
Earlier it was 170. Now it comes to 180.
Now my lord will come to page 165. My lord has it?
Yes.
Kindly see paragraph 7. Only such iron ore traffic as fulfills the conditions for treating it as domestic in terms of the provisions of para 3 above will be entitled to rates for domestic traffic.
What is para 3?
Para 3, my lord, I was showing before, my lord. My lord will kindly see these are compliances that are required. And it comes to the first page of the rate circular 161, para 3 is there. These are compliances that are required. The procedural compliances for.
What are those compliance?
My lord, for example,
there are so many
following
compliances.
procedure, the procedure is given. So now substantive part is at paragraph 7, which is at 165.
Yes.
Only such iron ore traffic as fulfills the conditions for treating it as domestic in terms of the provisions of para 3 above will be entitled to rates of domestic traffic. That is class 180. All other traffic of iron ore will be charged at class 180 plus distance-based charge as per para 1 above, which is a para 1 I had showed, my lord, the distance-based charge. So this is the dual notification of 2009.
There are
2009.
There are two charges in others.
Yes.
In other traffic of iron ore will be charged at class 80 plus distance plus base
Yes,
charge.
my lord. Yes.
That is 1.
Yes.
Suppose distance is 200 or 201 to
Yes.
203, 201 to 300, likewise.
161.
Up to 700, there is a percentage of charges, that is additional charge they have to pay for others. Regarding domestic, they have to pay class 80.
180.
180.
180.
That is
the
the
issue.
case.
That is the case.
Your case is that they did not pay, or they did not, they show domestic, but it was not domestic.
Correct.
That was the allegation
Correct.
in your case.
Correct.
That is
one
the
aspect.
that is the issue here. One, regarding rate circular. Other, I am not entering into it.
Now, my lord.
Now you come to the judgment of the Supreme Court.
I'm coming. I was just before the Supreme Court, I need to show a couple of paragraphs of the High Court, the division bench, and then I'm going into Supreme. My lord, will kindly take volume 3 of the revision.
Yes.
Volume 3.
ভলিউম 3 দেখুন, এর মধ্যে 9 আছে, 5 আছে, এটা 4 সাপ্লিমেন্টারি আছে এটা।
My lord, will kindly see page 415.
Yes, 415.
415. This is the High Court judgment. My lord.
Single bench.
Single bench.
This was affirmed by the division bench,
Division
and
bench. I'll
subsequently
just show those particular paragraphs only. I won't disturb my lord with the other thing. Now, my lord, if my lord sees this order, this law order stipulates that in 2008, this was the circular. If my lord comes to page 419, it shows thereafter 2009 circular was made, and this circular has been challenged 2009. My lord, now will kindly come straight away to 491.
yes,
My lord, kindly
490.
see paragraph 48.
Hmm.
This writ petition is disposed of in the following terms. Clause 6 of the rate circular number 36 of 2009 is valid and enforceable. The railway administration is entitled to impose penal charges in the manner prescribed in aforesaid clause or para 6. So this is a issue concerning us, and this is what was upheld. Now kindly comes to my lord, page 494. This is the division bench judgment, my lord.
490.
494. 490. Same volume, 490.
Yes, 94.
Got it? My lord, this is a judgment passed by Justice Bhattacharya and Justice Taposh Mukherjee on 24th December 2014.
Yes.
The relevant page is at para 521. Relevant part is para 521. Page 521. The last paragraph of this judgment, my lord.
Yes, 525.
521.
Yes.
The last paragraph, my lord.
Mm-hmm.
We thus direct that at the time of booking each consignment for carriage of iron from one railway terminal to the other by rakes of wagons, the railway administration realized the freight rate at class 180 plus distance-based charges as per para 1 of the rate circular number 36 of 2009. from the consignor and will ultimately decide the actual freight rate payable by the consignor on being satisfied about the actual end use of the iron ore to be transported under the consignment through railways, rakes and wells. So this is the relevant, it upholds that the distance base that has to be looked into, what actual distance is there, and based on that calculation, this has. So my lord, now my lord will kindly see the Supreme Court. আগে অর্ডারটা দেখা আরে গ্রাউন্ডসটা supplementary volume 2 টা
One Supreme Court judgment is also annexed 525. What are those?
500 and
524 in the same volume. What are those?
No, actually. My lord is looking into which document? Which volume, my lord?
Volume 3. Volume 3. Volume 3. You just refer 515, 500.
My lord, just one.
In that volume itself, one judgment of the Supreme Court is.
My lord, which page, my lord, is saying?
Page 524.
524. Yeah, keep it. So there. No. One of the same matters, these are part of those orders, earlier orders. I'll show the stay order straight away. These are a bunch of orders, my lord.
In this volume itself shows so many orders of the Supreme Court.
Yes, the relevant order I'll show. My lord, if my lord sees at page 531.
531.
There were orders at different point of time in this matter. Proceedings which are pending in the High Court will go on during the pendency of these petitions. These are all interim orders.
These are interim orders. You come
page 533. You have heard. Now, my lord will also bear it. This is a.
No, please come to 545.
Yes, sir. My lord, kindly bear it in mind. This has come before the Supreme Court from a writ petition. Writ petition challenging the rate circular.
Now 545. The division bench order was challenged.
This is the order that I wanted to show. This is the order. My lord kindly sees what is there. Sees from the first page, page 545. My lord will see from the top.
Impugned final judgment and order dated.
Arising out of impugned final judgment and order dated 2014, which is placed before my lord. In MAT number 1970 of 2014. Now, my lord will see the order. Now, my lord will be very careful. Upon hearing the counsel, the court made the following SLP number showing this the matter of January.
Following proceeding in following cases will remain stayed.
Before that. Before I'm coming there. Before that, my lord will see. Upon hearing the counsel, the first page, my lord. Upon hearing the counsel, the court make the following order. SLP C number 1589 of 1995 of 2000. With regard to that matter, this is the matter of 5th January 2016. Thereafter, my lord, issue notice by speed post with regard to TP so and so until further orders. Until further order, the further proceedings in the following cases will remain stayed.
So
Now,
all cases are from Calcutta High Court.
No, 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 my lord. No, my lord, multiple high court, my lord, can you see the first one? First case is Rashmi Metallics. And another was
One is from Cuttack, another is also Cuttack, Ranchi, Karnataka, and Calcutta High Court.
Right.
There are many from Calcutta High Court, Ranchi, Cuttack, and Karnataka. 4 states are involved.
Yes, because
and all are relating to writ petition challenging the red circular of 2009.
Yes.
Various writ petitions.
Various writ petition.
That is the
all are with regard to the red circular of 2009.
Now, my lord, I will place before my lord the SLP grounds. Their SLP grounds in this matter.
Now I understood. This is not relating to your 2009, the class 170 or 200X. Such issue is not before the Supreme Court.
Yes, my lord.
Supreme Court, the issue is with regard to the supersession of 2009 and thereafter 2016. That is the challenge before the Supreme Court.
Main or rate circular challenge of 2009.
No, I understood.
Supplementary affidavit volume 2 tabi.
Yes. Volume 2. Volume 2.
Volume
Supplementary.
Supplementary. In the supplementary.
Now please specify your cases with regard to the class 170 and 200X.
Yeah, because of the timeline.
Because your case is not with regard to the class 180.
At different times, at different periods.
No, that period 180 was not there.
Not there.
180 comes
so that,
in 2016.
That I will show it from the FIR.
So here,
before my period is very small.
I am not asking about the period. What is the matter pending before the Supreme Court?
Supreme Court, the circular,
Supreme Court pending regarding the circular of 2016.
No.
2009. But it was subsequently after supersession of 2008 published in the year 2016.
No. In 2009.
2009. 2009 different date.
2009 different dates.
Different date.
Different date circular came in.
That
was in supersession of 2008 circular.
What is the date? That was
2009 date circular.
Page number 872. I think you have shown.
Well, 2009 circular is 1st June 2009.
First after 9th May 2009.
No.
9th May 2016.
No. Page 161 again, my lord says. The date of the circular is 1st June 2009 which would be effective.
Subsequently, it was again notified on 9th May 2016.
Yeah, that is a different circular. That 2016 circular came in and said that this circular, instead of this circular, such and such rate, this will not be applicable for the period of such
That's
and
why
such.
I am asking you, after 9th May 2016,
Yes.
earlier class was changed.
Yes, on 9th May 2016 it
16.
was changed.
What was the class earlier? 170 and 200x.
Yes.
Two different,
Now
one
it
for
became 165.
domestic, another for others.
Yes.
That is your case
Yes.
in ED.
Yes.
Subsequently, it's changed to 180.
In 2016.
2016. That is pending before the Supreme.
In 16 it became 165. In 2016 it became
165.
165. Yes.
2009 or 180
No, 180. 180.
Yes, but in 2016 it became 160.
165. That is third time.
Yes.
So from the case pending before the Supreme Court, it appears that the matter is relating to rate circular of 2019, but with regard to class 80, not with class 170 or 200x. Is it correct?
It is correct.
But now next day we'll give reply then.
Interim order করে
Well, the irony is our on this matter, since the matter is pending in Supreme Court, main matter. Now, in order to apprise your lordship and in order to dispute that matter, he is consuming more time. Kindly see the irony, my lord. This is a simple prayer, my lord. The other honorable judges have also done so. Kindly
No. This is not so easy as you are saying.
My lord,
Not so easy.
Now my lord realizes
the Supreme Court is pending, so entire matter will be stayed. That will not be applicable.
My lord, he said just now,
If I find
taking so much
Supreme
time.
Court matter is different,
if so, it's not different at all.
that's why I am
Right,
hearing him.
That is the
my lord,
application.
Your lordship
My lord, he said
খুলে পড়ে গেল
that
এক মিনিট দাঁড়া
he
পড়ে
had
গেছে
taken for the last
এটা সাজিয়ে রাখবেন।
my lord, when will the
মানে উইল ডেমনস্ট্রেট my lord absolutely identically
Yes, আমি করবো, তারপরে তো
তারপরে
demonstrate
তখন
তো
বললাম
শেষ করি।
মানে when should you come back my lord?
Yes.
কত তারিখ বললাম দেবযানী সুবিধা?
হ্যাঁ বলে দিচ্ছি
24th.
No, she has some difficulties with this. 8th May.
ফিক্সড আছে 8 তারিখ।
আবার ভেকেশন পড়ে যাবে।
না ওটা পরে চলে আসবো।
8 তারিখ।
My lord, 3 p.m. and on 8th May.
3 p.m. I want to.
My lord, 3 p.m. every Friday is 3:30 my lord.
2:30.
Let it be at 2 o'clock.
My lord, I'm only saying on that day there's a time fixed at 2.
So then first half করুন না স্যার মানে সারাদিন বসেন তো ফ্রাইডে
টাইমিং নেই।
আমার
টাইমিং নেই তো বলুন।
12টার সময় করুন না
2:30.
2:30.
I'm under the interim order to continue then. I'm protected till 17.
Hearing is on progress.
have to dismiss the matter, my lord.
In this way, I will not allow.
But there is no opposite side, my lord. There is no opposite.
No,
It's the
in
first time, my lord, it has come.
I think that order has already been
My
typed.
lord, kindly, my lord. Your lordship knows, my lord, the difficulty, my lord. Item 22, my lord. 22.
22, I think no dismissed.
Yes, my lord, it is showing in the case status, it has been dismissed for default, my lord.
For default.
Yes.
Yes.
My lord, kindly, my lord.
Most of them.
The last chance syllabus, I guess.
There was no order in the server, my lord.
ঠিক আছে ওই অর্ডারটা রিকল করে দিন হ্যাঁ হ্যাঁ নট টুডে করে রাখুন নেক্সট ডে আই উইল ডিসমিস রিকল করে